DP, English v. Walker. This was, Miss Walker, or Miss English is in the courtroom. Mr. Walker is via Zoom. We had this hearing 2 weeks ago and I basically denied everything because Miss English didn't show up for the motion. She re-noticed it. Apparently on the same day that we had it. Don't know anything else other than that. This was her request for a confidential address and change of custody. The parties apparently from prior order have joint legal custody, physical custody 50-50, exchanged on Fridays. And so Miss English, what do you have to say? I read your motion. Like I say, I denied it last time because you just failed to show.
Yeah, I came. However, I haven't served him his copy, so I figured it wouldn't be fair if I, came in and didn't serve him his copy. And just due to the way that we don't communicate effectively, so it was really hard to try to get him the paper and then just.
Okay, well, he was here last week and he's here now. So what do you have to say? I read your motion from before. Saying his girlfriend is not nice to.
So I'm okay with Devenir as a whole. However, my concerns are the other people in the household, the way my daughter is treated, and then the way that we cannot communicate effectively for anything. I was supposed to have her on Mother's Day. I didn't have her. I was supposed to have her on other days, like he just made.
Is it in the judgment that you're supposed to have her on Mother's Day?
Yes, it
Then
was part of our order that I was supposed to have her on Mother's Day. And then he didn't give me the opportunity to have her.
If he violates a court order, file it with the friend of the court. It comes in front of me and I determine if somebody's in contempt.
Okay.
So it's that simple. I can tell you guys to get along and communicate, but I can't force it. There's no other way. The two of you don't communicate, so the two of you don't communicate. It's too bad and the child will, will suffer some from it, but other than that, I don't. I mean, you want a confidential address?
Yes.
Why?
Because I don't like the drama. I don't like the arguing. I don't want the troubles with his girlfriend or mom and sister. I really don't have a good relationship with them. They're threatening. They
know where you live, don't they?
No.
Well, then what's the conflict? What do you need a confidential address if they don't know where you live?
The address is for them. It's not for Devenir.
It's
for his family members.
Will his family members come over to your house or what?
Yeah, they used to. I used to have a lot of issues with the family.
But do you care if she has a confidential address, Mr. Walker?
No, because there is no issue. So
that's fine. I'm just asking you. Well, all right, you can have a confidential address. As far as custody, in order to change any type of custody, which you're asking for, you have to provide proper cause or change of circumstance according to a case known as Vidvarka, and there's nothing in your pleadings that would tell me you met Vidvarka. I'm trying to find out what you think would meet proper cause or change of circumstance from the last custody order.
Because for one, Devenir is not legally on a lease. My daughter is not supposed
to. Doesn't have to be on a lease.
My daughter is not supposed to. Huh?
She doesn't have to be on a lease. The daughter.
No, not my daughter.
Doesn't have to be on a lease. He's living wherever he lives and there's nothing. I mean.
Well, I wasn't assigned to a lease and I was considered unfit or unable to provide for my daughter, even though I still had a stable place to stay.
If you were, I mean, I don't know when you're even talking about.
Prior to this appointment, to this court date.
Who told you? I mean, you guys don't.
I put in a request for custody because he's like, she's homeless and I brandished a weapon at somebody and all this other stuff or whatever. So he put in a change of
Yeah.
custody thing or whatever, you know, and even with that being said, like I wasn't accused of anything. Like, yes, I was attacked. I went through a situation, you know. However, like at the time and when I needed Devenir's help, I was called out of my name. I was disrespected. I wasn't helped. Like it was just a bunch of drama that we didn't need.
Okay.
Versus him helping me, he like downgraded me and disrespected me, called me out of my name, and oh well, you got to go through.
When are you talking
CPS
about
to
on
get
this?
help, and
When
it
are you
just-
talking about?
It was wrong, huh?
When are you talking about?
I'm talking about prior to.
I know, but like 10 years ago, 2 years ago?
In December, right?
Okay,
In December,
what happened by it?
December. Back during when we were going through our other case, but when we were going through our custody case.
All right, but there's a consent order regarding custody, parenting time and child support, January 30, 2024. What has happened since then to that, but VARCA would be met? Proper
My
cause or
daughter-
change of circumstances.
My daughter is not happy. Her attitude.
That
she
can't,
doesn't-
that, I,
she
you
doesn't
sent in a
get
letter to
property.
me and I do not read kids' letters,
Doesn't get
not at all.
I'm sorry.
I do not read 11-year-olds' letters. I have under no circumstance is that appropriate for me to read that.
Okay.
And so all I'm saying is that she says she's not happy. Okay,
She's not happy. She needs to be in a stable environment. Me and Devenir can't even agree on a school for her to go to. Like this year, it was extremely hard for us to agree on what school she's gonna go to. He called me out of my names and was just very disrespectful in front of my daughter for no reason, and I'm sick of it.
Mr. Walker, do you have an attorney on this matter?
Yes, Kristen should be
Oh, from-
coming in. She just texted me.
All right, I didn't see anything filed, so.
Yeah, she's supposed to be in. She just texted me and said that she was letting the clerk know. So I don't know when she'll be popping in.
Sir, you can just mute for a minute. We're gonna see if we can get your attorney. Ma'am, you can just wait for a minute here. We're gonna see if we can get your attorney in on this matter. And we'll take on another case. So just mute yourself. And I'm gonna take another case here for a minute.
Hello?
Hello, just a minute.
Yes, sir.
We have to put you back in because you needed to notify the prosecutor's office because this is their case. You didn't do that, but they've agreed to come in on this anyhow. But she's not here right now, so we're gonna have to, we'll wait a minute.
Yes, sir.
And we'll put you back in the waiting room to both of you until we can get the prosecutor here.
Yes, sir.
¿Dónde está mami? Is there a photo, mommy?
All right, this is Delgado Rosales versus Carbajal. Delgado Rosales versus Carbajal Gonzalez, both parties present via Zoom. This is Dad's motion regarding child support. However, sir, the notice that you gave was for 7/6, was for September 6th for this motion. Ma'am, I think you got some stuff from us, and actually this is set for the 6th, 2 weeks from now. Do you want to just proceed at that time?
We can do it right now.
All right. Sir, you would set it for the 6th. You ready to proceed now? Mr. Carbajal?
Yes, somebody speak Spanish?
What?
Somebody speak Spanish?
No, did you ask for an interpreter?
No, not today because I have it like in the notes I have it like next week or September 6th.
We don't have an interpreter, and if you need an interpreter and it's your motion, you got to ask for an interpreter when you file this motion.
Yeah, because the motion I have it like next month is 6. I don't know why it's
All right.
today.
Ma'am, we'll hear this on the 6th. We'll put it on for the 6th.
Yeah, because I
Okay.
have it like
All right,
Okay.
thank you. We're adjourned.
Yeah.
We'll see you on the 6th.
okay. Thank you.
Ms. Wolfram, you are here representing Mr. Walker, I take it.
Yes, that's right.
I don't have any appearance, but I'm assuming you filed one and or will promptly.
We will. We were actually considering filing our own motion because my understanding, and I haven't checked in with Devonair this morning, but that she has been violating the parenting time schedule for some time. So we were going to be filing our own. So I haven't filed in hers, but
I've already said, I think, Mother, we started because I didn't know you were on it.
understood.
Ms. English is here in the courtroom. Mr. Walker is obviously on Zoom, and we're back on the record on 15-7672 DP. She started by saying, you know, he didn't give her Mother's Day and he was supposed to. And I warned both of them, if there is parenting time violations, the first step you have to take is file it with the friend of the court. Any parenting time violations must start out there, and we see what happens from there. Your client agreed, said he didn't care if she had a confidential address. So
Correct.
we'll grant that part of the motion. I've been asking Mother what it is that has changed since the first of the year, because that's when there was a agreement of the parties. And has the latest custody, parenting time, child support order. That was agreed. Parties will have joint legal and physical of the minor child. Regular parenting time, the parties will alternate weekly parenting time with each party beginning on Sunday at 6. All right, that's where we're at so far. She was indicating they can't agree on anything. They don't get along. I understand that, but I don't know that does not provide Varka, ma'am. Or let me ask, where's the child attending school? You prep?
Yes.
Okay. I can't imagine there'd be any problem with that. Both parties.
He said that I would be the only one transporting because he's not gonna transport
Well,
her.
I will tell you this, if she's attending school, and Ms. Wolfram, you know, and he's got week on, week off, he has to transport when he's got her, and you gotta transport when you got her. I mean, that's all there is to it. There's nothing to it other than that. Anything else? I mean, Ms. Wolfram, I'm gonna tell you right now, I don't see any Varka in the pleadings or what she has told me here today. There's no real change of circumstance or proper cause. The bottom line is the parties don't get along, and they probably haven't ever gotten along. So I don't see anything for change of circumstance. Miss English has said that his daughter is, I don't know, depressed or whatever, you know, but each party has to take their time with the child. They have a real specific time, Sundays at 6 p.m. Who has the child right now, ma'am? You or him? You. So at 6 p.m. on Sunday, you get her at Checkers on 28th Street. And
Can I speak?
Myers.
you've changed the place? Myers on 28th Street or what? Kalamazoo?
Yeah.
All right. So that's where you'll exchange. There is a time in here, you know, mother gets Mother's Day, father gets Father's Day. There's a complete order that I think you have probably seen, Ms. Wolfram.
I think I wrote it.
And yeah, and I mean, the bottom line is you follow that. Anything you wish to say, Ms. Wolfram? I mean, I don't find Varka, so there wouldn't be a change of custody at this time.
No, not asking for that. I think my client was happy with that order. I would agree. There's no change. I think I would just probably state for the record, while my client does not care to, have her address as far as it being confidential. I think that one of the problems is that she's previously been in homeless shelters and been not disclosing that to my client, which is what one of his concerns were. So I think she has to keep updating that with friend of the court. Other than that, I think
She is responsible to update it with the friend of the court, but she has just told me here that she has a lease.
Perfect. And so then we would just ask the motion be denied and that she adhere to the parenting time schedule, and we'll follow up with the violations from previously, when she previously violated.
You can do that, ma'am. I'm not gonna change custody, but you understand, you don't have to tell him your address, but you have to tell the friend of the court where you're at, because they may file something.
Have like CPS is investigating him. My daughter is in counseling. We've been through more than enough. So I'm just doing what I gotta do as a mother to protect my daughter and to make sure she's healthy mentally, physically, all the way around. Like, I don't feel like it's fair that Devonair makes things so hard and he's so disrespectful in front of my
Can I
daughter
speak?
so much. And it's not right that I have to tolerate that, and it affects her. It affects her attitude. It affects how she deals with both of us. It's not fair that he makes it so complicated.
All right, I can't
Can I speak one time?
No. You've got an attorney and she doesn't want you to say anything right now. And it's fine. Mother's saying what she says. I understand. It doesn't change any of my ruling today. There is no proper cause or change of custody for a proper cause or change of circumstance for change of custody. So therefore, I will grant that she has a confidential address. Obviously, she must. I'm assuming you're saying you're not homeless. So, I don't.
Send in a copy of my lease.
Yeah, I understand. And you don't, I don't need to know. All I need to know is that she has.
Not on Section 8.
So, that's fine. So, Ms. Wolfram, anything else?
There's nothing pursuant to this motion. It should be denied.
Yeah, other than the granting the confidential address.
Thank you. Yes.
And ma'am, make sure you keep the front of the court. If you find yourself in an unfortunate situation of being homeless, make sure you take appropriate action. All right. Good luck, everyone. I'm granting confidential. Sir, you call Ms. Wolfram after this. All right. Although she's got other motions. Good luck. Thank you.
Okay.
We're adjourned.
Thank you.
Thank you. Good morning, Mr. Romero.
Good morning, Your Honor. There you go. And I look for a little spot right over here.
All right.
Buenos dias. Good morning.
Good morning. We'll get you seated here. While you're walking, maybe you can raise your right hand. Do you solemnly promise to or affirm that you will interpret to the best of your ability and not divulge confidential communications?
Yes, I do, Your Honor.
Thank you. Nice to see you. I guess I'm not sure who needs the interpreter here, but you can introduce yourself if you like.
Eduardo Romero, voy a ser su traductor en el día de hoy.
Okay, ¿cómo está Eduardo?
Hey, how are you? Good. Thank you. Gracias. Bien.
Ms. Torres, are you there?
Yes, one second. I'm having a little bit of trouble there.
Okay. We're here in Cartagena. Torres versus Valerio Castillo. This is a motion filed by the plaintiff, Ms. Torres, seeking determination of a child born out of wedlock. This matter is a divorce with children, but she claims that the defendant is not the father. At the time of the filing, the child was not even born. Subsequently been born, I don't know, a couple months ago, I suppose. Father was defaulted in this case for not answering. However, there's been no determination that he was not the father, and since they were married, he is the presumed father. Ma'am, you're asking that I determine that he's not the father, but I don't have any DNA evidence to show that.
Yes, I have did DNA test.
Yes. I have nothing in the file to show that he's not the father.
Correct. I have been at the Legal Assistance Center, and I did get the results of a DNA test that I did on Friday last week. So I have that email.
Who did a DNA test?
It was called the Fastest Lab on Kentwood.
And that was Mr. Castillo and the child?
Yes,
no, I did it with the father of the child.
Well, I don't have that here, so I can't make a determination that he's not the father. If you want to adjourn this for 2 weeks, we'll come back in 2 weeks. You can present DNA testing and we'll see what happens then.
Yeah, I wasn't advised, but I've been working with the legal center, and they didn't tell me who I was. Like, they told me to wait until the hearing. To my understanding, it was just wait until the hearing and present it here, but it was an email.
Well, does Mr. Castillo think he's the possible father?
No, he does not.
No.
Mr. Castillo, do you think you're the father?
No.
Any chance you could be the father?
¿Alguna oportunidad que usted puede ser el padre?
No.
All right. What I'm going to do is adjourn this for 2 weeks so that I get the paperwork that shows who is the father, and I'll make a determination in 2 weeks whether we eliminate this, him as father or not. All right. File documents to prove DNA wise that Mr. Castillo is not the father. And in effect, if you prove who is the father and it's not Mr. Castillo, I'll take
Where
that.
should I leave those documents to? Is the second
File them
floor?
with the court.
Entábrelos a través de la corte.
Okay.
Okay.
Down at the same place you filed the motion and everything. Thank you.
Thank you, bye.
Mr. Romero, do you have any others with us, or?
I don't think so, Your Honor, but it was nice seeing you.
Nice seeing you. Take care. Have a great weekend.
Bye-bye.
Adjourn.
Hasta luego, señor. Bye.
Hasta luego, gracias.
Do I dare say one of my favorite attorneys and then let them figure out who it is?
I'll just assume it's Mr. Peterson.
I'll assume the same.
Mr. Peterson, I take it you're not going to be on video.
I've got the video on, and I just had this issue with Judge Gardner as well, but for some reason it's not picking up a video. So,
All right. Well, I don't know what that could be, but we.
I can neither confirm nor deny that's Mr. Peterson.
He just left us and it's back. Even his camera doesn't want to look at him.
that's probably true.
All right, we're here in Allard versus Allard. Kristen Allard, are you there? You're muted, but I want to make sure you can hear me, and if possible, you have a video.
Yes, I'm here.
There we go. All right. Both parties are present with their respective attorneys. Plaintiff is represented by Ms. Van Dyken, defendant by Mr. Peterson. It's a motion for orthodontic treatment. I have a letter from the orthodontist stating that it appears to be medically necessary to have this orthodontic treatment. Mr. Peterson, your client, doesn't want it at this time. Seems to think Dr. Harriman's only in it for the money.
Well, I think there's more to it than that. This minor child. But
no, that's what he emailed to her. So
yeah, and at this time he doesn't think it's appropriate. The problem is, and my client has tried to get in touch with the orthodontist since we received this motion. Unfortunately, he was on vacation. The orthodontist was until yesterday. My client contacted him several times.
All right. And that's it? Or you just, I'm assuming that wasn't the end of your presentation, but if so.
Did we lose him?
Well, are you there?
This is Brian. I'm here.
No, I know you're there, Mr. Peterson. It shows everything's connected. Now he's gone. We're off to a blazing start this morning. Everything I've had has been adjourned, or we can't get connected or something.
I've tried to text him. I'm not getting a response either. Oh, he's reconnecting, he says.
All right.
Want me to make his argument for him?
Yeah. I've heard enough. No, I'm just kidding.
Why we schedule these on Fridays? It's the end of the week.
Yes,
Not
tell me
Monday.
about it. Tell me about it. Every other week, this is the dues I gotta pay.
Choices.
Is he reconnected? Nothing?
Your Honor, if you want to take another one, but Miss Allard is in class this morning. She can't miss her labs. So if we come back and she's unavailable, would the court allow her to continue with her education?
I'll leave that up to you.
Okay.
If you want to continue without, we
Okay.
can. That's strictly up to you.
Okay.
If you want her to be present and she gets out of labs at 11, we'll come back at 11 or whatever. That's up to you. Miss Allard, what?
I have class until 4 today, but I think we have a break at noon for lunch.
Miss Allard, I don't think I need you for the motion. I'd rather, we did our written motion. So if you want to go back to class while we wait for Mr. Peterson, I think the court will take other motions before ours while we wait for Mr. Peterson.
Yeah, I've got to take another one here because Mr. Peterson isn't connecting. And we'll get back to you real soon. If you can be out of class, that's fine. If not, yeah, I'm sure you feel that you have to be here.
I'm missing class right now, but I can go in there, and if I just, if I don't know, I don't really want to miss it because if I miss too much, I have to pay like $300 an hour to make it up, and it's an all-day thing. So if she doesn't need me, you know, I would like to
She's back
attend.
on, so we'll try it right this minute, okay? And if it doesn't work, you can go back in, and Miss Van Dyken, I'm sure, is more than capable of handling. This matter, I've read
Okay.
it and understand. All right. Mr. Peterson, you're still not visible, but quite frankly, you're back, I think.
I think so as well.
Well, I assumed that was the end of your argument. Just kidding.
I don't know what you heard and what you didn't there.
Nothing.
Go
ahead.
My client contacted the orthodontist office shortly after we received this motion about a week ago. And he was told by staff that this is not medically necessary at this point. He was told that the extraction of the tooth and spacers were necessary at this point. My client had appointments set up for those two items to be taken care of. Those were canceled by Miss Allard for other reasons. So that hasn't happened as of yet. My client's attempted to also speak with the orthodontist, but he was on vacation all last week up until yesterday. My client tried to get a hold of him a couple times yesterday, was unsuccessful, was told by the office that he was extremely busy yesterday. And so he has information that this is not medically necessary at this point, that only the spacers and the tooth extraction are right now. And that's why he's saying, let's push this off, because otherwise, my experience with orthodontists is you put a child this age in orthodontics, and then when they're a little bit older, they have to go through the same thing again. This child's already been through braces one time, and so her teeth are in pretty good shape right now. And there's no real medical reason for this to happen right now.
Doctor states in a letter, if not corrected, this would lead to whatever that word is, joint disorder, abnormal wear of the teeth from something, possible pathologies. All right, Ms. Van Dyken, what do you wish to?
Your Honor, Mr. Peterson has a whole bunch of hearsay. If that was accurate, I don't think this letter would have been written. I don't have an MD degree, I got a JD degree, but when a doctor tells me that something, comprehensive treatment to restore proper function, I think you start early so you don't have later in life issues. So I think that the following the direction of the orthodontist is appropriate at this time.
Your Honor, they did tell me that he would be available and they could get me the letter next week when they called me back last evening.
All right, but what letter?
Well, the letter just indicating what I indicated to the court is that it's not medically necessary right now. The only thing that's medically necessary is the spacer and the extraction of the one tooth.
That letter would seem to be contraindicated by the initial letter.
Then, I mean, he's known that this is coming for a while, as I understand it. When
we've known about this.
You've known about the motion, but apparently before that he was informed of it.
We had this
Correct.
discussion
And the parties
when we were going through the child support issue.
Yeah, I'm sorry.
And the parties texted regarding this issue, and it seemed in my review of the text that they agreed that they were going to go forward with the tooth extraction and the spacers. Those appointments were scheduled, but they weren't going to go forward with anything else at this point. And then we received this motion.
Can I say something?
Sure, go ahead. It's free for all.
Brian had called me and told me that if I wanted my kids to have braces, that I would have to pay for it. So I was talking.
I never did that.
That's 100% accurate. That's why I know that he's not going to pay for it. So if he doesn't think it's medically necessary now, then when? The dentist thinks it's medically necessary.
Well, look at
Kids to have what they need. That's all.
what I have here is a letter that I'm not a doctor either, okay? And I'm going to go along with what the orthodontist says is appropriate for the time. Treatment would involve a full set of orthodontic braces and the extraction of a permanent tooth. The only thing I'm going to do at this point is I'm going to authorize the treatment pending, but I'm not going to issue the order for 2 weeks. If something comes through in 2 weeks that says, wait a minute, it's that the doctor says, no, it's not appropriate. Mr. Peterson, you can get back in front of me and tell me about it. I don't know what the doctor says. From here, it says she will benefit from comprehensive orthodontic treatment to restore proper function, and then goes on to say what it is. Unless you can convince me, because you're saying, you got a letter coming and all this kind of stuff. If you get the letter and send it to Miss Van Dyken in the next week, and you want to come back on it, I'll look at it again. He won't start comprehensive, I'm sure, within the next 2 weeks. I don't think braces will be put on. Is she scheduled at all yet for this tooth extraction? Anywhere?
She was scheduled. The appointments were canceled. I don't know if they've been rescheduled at this point.
I took her to the dentist or the surgery place to get it evaluated. I made the appointment to get the tooth extracted. Brian told me he didn't want to do braces, and my daughter wouldn't take her pre-med.
When is
The appointment in mid-August, so I canceled it. She had the appointments to get her spacers that I also made, but she didn't get her tooth extracted, so I had to cancel those as well. So yes, I have to reschedule in order to get her tooth extracted before we can get braces. That's why I had the tooth extraction scheduled, so she could move forward with her braces. But I can't afford to pay up front for these braces. And one person is responsible when you sign the papers, and I can't be responsible. But she needs to get them.
Whenever it's determined, the person is going to be responsible in the percentage that's appropriate in the child support order. Okay, whatever that is.
But at the orthodontist, they make one person sign the financial agreement. And so if I took her to get her braces, I would have to sign it, but I can't be responsible for all of that.
Well, but whatever the percentage is, that's who's going to pay it. All right.
Okay.
I guess what I'm saying, I assume you aren't going to be able to make an appointment for her in the next 2 weeks. You may make the appointment, but she won't be in within the next 2 weeks. Is that a fair statement?
I think
for braces or for the tooth extraction
first.
Yes,
Yeah.
that's correct.
That can be done. That appointment can be made and scheduled.
That appointment can be made, the extraction can be made, and we will see whether it's just the spacer or the braces. It seems to be the main thing. And isn't that correct, Mr. Peterson, Ms. Van Dyken?
Correct.
The spacer goes in no matter what?
Correct.
Yeah.
That's what it sounds like to me.
No, it's the spacer or the braces. The braces are more or less to keep the spot open, or they can do a spacer to hold the spot open while the tooth comes down. Miss Allard wants braces because she's worried about straight teeth. Her teeth are straight. She has good teeth. She needs minor adjustments, if anything. And Miss Allard is.
Mr. Allard, I don't know that you're an orthodontist either. Okay.
I'm not, but the main concern is that impacted tooth, getting that spacer in there and letting that come down. The orthodontist, I spoke to him last week, and the lady told me there may be an issue when she's 30 or 40 from whatever thing they said in there. But she said the orthodontist had to make the ultimate decision. So, and he was gone all week. So they told me today he does that, and it'd be next week before they could get me the letter.
You got the week, and you can send it to Miss Van Dyken. I guess the best thing is to set this off 2 weeks, but I intend to follow the orthodontist, what they think is the best route to go. I'm just telling you. If you want to get that to Miss Van Dyken and they are convinced that we can do it some other way, then fine. Otherwise, I'm going to order the orthodontic treatment. But I don't have anything right now other than the doctor's statement. The treatment would involve a full set and extraction. If not corrected, this could lead to whatever that word is. All right.
We'll try to get a letter in English and provide it to the court and Ms. Van Dyken.
All right. Do we want to just come back in 2 weeks?
I think that would be fair.
I don't think 2 weeks is going to make a big difference, but I'm warning you right now that unless the doctor says, no, we can try other things, I'm going to order it. All right.
No, that's understood.
All right. Ms. Van Dyken, he'll get you the letter, and we'll just set it up for 2 weeks from now and see what happens. All right. Everybody understand? We'll see you.
Thank you,
Your Honor.
Thank you. Hutchison versus Ferentz. Miss Hutchison is in the courtroom. Mr. Ferentz is on Zoom. This is the plaintiff mother's objection to the friend of the court recommendation. There's an objection to an 8-5 recommendation that I don't even see was sent out anywhere. Ma'am, the only thing I saw that there was a recommendation from the friend of the court was child support.
We had attended a meeting with the friend of the court for mediation, And we had covered several topics. Everything was in agreement and we were fine. But when the final paperwork came through to us via email to sign, there was some wording in there that I was concerned about.
I don't have any of it. I mean, your objection to a friend of the court recommendation may be an objection to a friend of the court order, but it's not you guys agreed on stuff. I don't know what you're asking for.
Well, we had changed our custody schedule. We had changed the children's school district. We implemented a following the new school district's holiday schedule. All of these things were discussed in mediation. And like I said, we had agreed to everything. It's just that there was some language in there that was a little ambiguous and I was worried that it could be used as a loophole later. So I just wanted to make sure that that was corrected. So I'm not, yeah. The friend of the court just told me to file an objection and to come here and discuss it.
Sir, any thoughts on this? I don't have anything in front of me that, first of all, I mean, it's not a friend of the court recommendation. It's a friend of the court order that they drafted pursuant apparently to an agreement that you guys have made. Is that correct?
Yes, sir. So what had happened was that she wanted to get extra timing in order for the school to go here. She gave me an alternative or, and either keep the school in Rockford or give her more time to keep the school here in Grand Ledge. I don't want to travel my kids.
None of you live in Rockford, do you?
Correct. And it's an hour drive and I live right here and it just makes the most sense. We've already got them enrolled. I did agree with the plaintiff about giving her holiday time and extra time. She doesn't like the fact that the wording in the mediation says that she's allowed 52 days in summertime, but if we don't agree, it goes week on, week off. I like that because in the event that my kids need to be here or don't want to be there, they have the option for that. I've had them for almost 2 years.
Whoa. How old are these kids?
8, 11, and 14.
Yeah, they don't, you're the parent. They don't just say, oh, I don't want to go to mom's.
Correct. I understand that.
Okay. That's just basically what you said.
I apologize. I didn't mean it like that. I just want them to feel comfortable and not forced into what,
Well, they don't have to feel comfortable. You have to force them. I mean,
yeah, I understand that. Yes.
All right.
They've just been with me for most of the time, Your Honor. That's all.
What, ma'am?
So we have been in agreement for the most part since our divorce was finalized in August of last year. Initially, the children were with him 4 days of the week, 3 days with me, which included weekends. I was okay with that schedule because during the weekends, I had more time with him. I thought that it was fair. I would like a 50-50 custody schedule, which is what was being discussed here. We had both lived in Rockford. I relocated to Middleville, which is an hour away from Rockford. He relocated to Grand Ledge, which is an hour away. I brought up multiple scenarios for him to decide on. I said, look, I would prefer to have them in the schools here because it's part of the Rockford school system still, Kent County school system. And he wanted them to go there. I said, okay, well, neither of us are going to agree on one or the other. Let's choose a school district that's in between. He said no to that as well. So we went with the kids going to Grand Ledge schools, but in order for that to happen, I said, okay, well, let's at least have them here with me extra time during the summer so that it is a true 50-50 schedule. So they're with him 4 days of the week going to Grand Ledge schools. They're with me 3 days of the week, however they make up that extra time during the summer. That's the only reason that I agreed to them going to school out there, as opposed to us continuing to hammer out alternatives like them going in between where it would be more convenient for both.
You realize the school wouldn't, if you guys came into the court, I wouldn't pick a school in between.
I don't know how it works. We've never done this.
I understand, but it's called the Lombardo hearing. If you guys can't agree on it, why would I pick a school in Portland that none of the kids do? They would go there, they would have no time they'd make friends and then they'd leave. Okay, I mean, there's no way that would do that. So one or the other. I mean, it's just like saying that the kids would continue to go to Rockford. That seems to be just ludicrous because both of you have to drive an hour to get there. All right.
Yes, sir.
It was agreed that it was in the best interest for them to go to Grand Ledge, but like.
Are they enrolled there and have they started in Grand Ledge?
They are now enrolled and we did orientation this week.
All right.
And they start Tuesday.
Yeah, we have just been going along the course of action that we planned out and waiting for this to get, taken care But otherwise, like I said, everything was fine. I was just concerned about the wording in the mediation.
And I don't have it in front of me. I don't know what it is. Nobody presented me the order that says the proposed order, and this is what I have or what I don't have. It sounds like he agrees that you get 56 days in the summer. Is that what this is?
Correct.
52.
52 days in the summer?
Yes, sir.
And
And if we don't agree, it goes week on, week off.
That's my concern. So in order to maintain 50-50 custody, I'm getting those extra days during the summer. However, it says in the wording, if the parties are unable to agree to a schedule for the summer, the parties will exercise parenting time during alternating weeks. So if he disagrees with the schedule that I sent to him for the summer, then it just goes to week on, week off, and that eliminates the extra time. that the kids are supposed
when do you have to notify him of the extra time you want?
The end of May, but it just.
By the
says
end of
that
May?
if he
Why-
disagrees-
Hold on. He should have enough notice so that he can make plans too.
Oh, no,
Okay.
I agree completely
And-
with that part. My concern is just that, I'm not saying he's going to be contentious or that he's going to disagree purposely, but if he were to disagree, then it reverts to week on, week off, and I lose that extra time that was promised. That was the whole reason for me agreeing to them going to Grand Ledge schools. I'm taking on the extra burden of driving out there an hour, attending their school events, attending their sports events. I just asked that they be with us for extra time during the summer. And so if he does not agree to a schedule I send or anything that I try to work out with him, then it reverts to week on, week off, and I lose that extra time.
What do you intend to do in the summer? What,
I don't know. We do things during the summer, but we don't have a set schedule or anything. This last summer, we just worked it out between the two of us. So, like I said, I'm flexible as far as scheduling. I'm not rigid, like we need them this time. We custom tailored it. And in fact, he was the one that came up with the final schedule. He sent me several drafts. I need them for this time. Oh, actually, I need them for this time. Well, I just found out about this party. I'm going to need them for this time. And I said, okay, that's fine. We'll make it work. I just want to ensure that those 56 extra days are definitely going to happen during the summer, and that if he changes his mind on a whim, it can't just be like, okay, well, now it's off and you just lost your extra time with the kids because there's this loophole in the wording. That's the only thing that concerns me. I don't know if I'm.
I understand what you're saying. Your response, sir, you're agreeing to having the number of days in the summer and
Yeah, is there any way that we could eliminate?
It's the Eaton County schedule, Your Honor.
Is what?
It's the Eaton County schedule for child custody is what we're going off of and what the mediation is going off of.
No,
That's why I wanted to go.
That's a suggestion. That's not something that's, has to be done. The kids are, I don't know why you'd have the Eaton County schedule. They're in Kent County. This is where you are with the case. Okay.
Oh, yes, correct. Yes.
So,
Your Honor, I'm just worried about the schooling and making sure that they're here and being able to do events here at school. And so that's all I've, mainly cared about, and that way they're safe and
figure out
not travel
wording.
back and forth.
And I don't have this order, so I don't know what I'm doing with it, other than to say you should make an agreement that you'll finalize the schedule by May 15 or something of each year.
That's exactly what we have.
And that if somehow, if it's not agreed to, you have to come back in front of the court. I understand what she's supposed to do, and I am a little concerned with what you said to begin with, saying, well, maybe the kids don't want to do this and stuff like that. No, that's not part of it. Although it's going to be, the reality is that one child's 15 or 14.
Correct.
What's going to happen 2 years from now when the child gets a job? Where's the child going to work? In Grand Ledge or in your place, if they want to get a job, and what are you going to do with it then? These are real considerations that are going to come up because kids get older. They're going to get a driver's license. Where's he get a driver's license, or where's she? I don't know whether it's a boy or girl, but these are going to be issues that are going to come up no matter what I do, no matter what you guys do. Those are legitimate issues that I would lean towards the kids one way or another. But at the same time, I guess you should be able to propose maybe by May 1, you propose the time you want. By May 15, he objects to anything. If you can't figure it out, file a motion, come in front of the court, and I don't know what else to do. Because by default, if it does go to default, and say the kid's got 10 weeks in the summer, just as a, all right, what is that, 70 days? She'd get 35, you'd get 35, and she's way short of what she's supposed to get extra. All right? And that's it. Maybe you just put in there that, you don't do the default, that she gets the extra days, in the summer, and that the parties will, figure out the summer schedule by May 15. And that's it. I mean, both parties are gonna have to be, amenable to some give and take.
Oh, absolutely.
You know, both parties are. So I don't know, because I don't have the order in front of me. Why don't the two of you talk about it and take that out, maybe that it defaults to week on, week off? Just that she gets the time, and set a time when she has to notify you what she wants in the summer. And you know, unless there is something really specific, that's what she gets. All right, I mean, if you say, wait a minute, that weekend that you want, I've got my family flying in from San Diego for the weekend for a family reunion, exchange sometime that, you know, there, but it should be only really that, okay? She should get first preference unless there is something really, I don't know.
My problem, Your Honor, I came to you, we came to you, you know, a few months ago about this situation, which was trying to transfer the schools in general. And you just said that if we couldn't figure it out, go to mediation. I really didn't want to give up my time, but I understand that she wants more time, and that's understandable. Those are her kids as well. It's just hard for me just to say, okay, yeah, I want to give up my time. It's like giving up my rights in a way. We have 60-40 split right now. And that's what her schedule, she's the one that put it in there. You know, and that's what we've been doing, but I'm totally okay with giving her, you know, the extra holiday time and stuff. So that's why I wanted to go to the mediation, and that's what mediation was for.
That's
and
the purpose of mediation, is to try and figure stuff out, because you want your time, she wants her time. It sounds to me like she gets basically every weekend and you get the school week.
Yeah.
And and I'll tell you, quite frankly, that isn't necessarily fair, because she gets all the fun time and you get the school time. But
thank you. And then take away the summertime.
But you want it to go, but that's the way you want it to go. If you guys cannot reach an agreement, I have to have a hearing. All right, and make a determination. There's nothing else. You guys either are gonna reach an agreement. That's the purpose of mediation. I can't force you to reach an agreement in mediation. If you don't, you don't, okay? If you do, you do. And so, that's all I can say. Obviously, you have said that the kids can go to Grand Ledge, and they are going there. It's unlikely that they're gonna be changed from there, because they're going there, all right? So, you tell me, I'll have a hearing on, appropriate parenting time if you guys can't reach an agreement.
Okay.
Is that what you want?
That's fine with me.
Yeah, I suppose so. I guess to like I said, the only issue is just the language is ambiguous, and I'm concerned about that. But like you said, if we could just eliminate that portion,
He says no, okay? I can't make you guys agree on something. It's
We
just.
did agree, it's just the way that they worded it. That's the only thing I came back saying, if they can't agree, then it defaults to week on, week off, which, you know, like I said, was the concern, that then it eliminates.
I understand what you're saying, and I understand what he's saying, and I understand what I'm saying, okay? That if you can't have an order that you agree upon, or that can be forced upon you by agreement, okay? We have to have some kind of hearing, and I have to determine what's in the best interest of the children for parenting time or whatever. Right? I don't know what else to say. You don't agree with the wording. You don't think it's what you agreed upon in there. He likes the wording. I don't know that he believes that it was agreed upon necessarily, but.
He signed, I did not sign because I was concerned about the wording.
All right.
I filed the objection because that's what they told me to do.
And you say that was not what was agreed upon in there.
Yeah, I didn't know that they were gonna word it in that way, saying that, okay, well, we're gonna default to week on, week off, because that eliminates the whole point of having.
I understand. I understand so I don't know what else to say other than we gotta have some kind of an evidentiary hearing. to try and, you guys have to come in and convince me what parenting time should be. All right, I mean, we aren't gonna get to this like next week. You'll be lucky if you get it later in this year. It's in November before we have it. In the meantime, continue on. This is really summer related, so we've got plenty of time to do this. All right, we'll set up an evidentiary hearing. You're gonna get a notice of what it is. It's gonna say on it things about like, trial briefs and exchanging witnesses or stuff. You have to follow that. Read it, okay? You have to follow that. We'll see. It's normally in court. I know you're an hour away, but she's an hour away. I'm not quite an hour away, but you're both far enough away that you can probably both show up in court to do this.
I can be there.
In the meantime, don't stop trying to figure it out, all right? Because otherwise I gotta figure it out, and I don't know either of you, okay? And I don't know your kids, and I'm gonna figure out when they should be visiting with each other. You don't not get along. I mean, I don't know how to say it. There are people who I'm gonna deal with today who just simply, one of the early ones you were sitting in here that, geez, oh Pete's, they can't even be in the same, vicinity, to each other. You've got kids together, hopefully you can figure it out. All right, but we'll set up an evidentiary hearing for parenting time to decide what is appropriate parenting time.
Is this something that's going to be sent to us? Or is
Yes.
this something, okay, so we'll get something in the mail.
She'll send you notice to both of you, all right? In the meantime, kids, hope they do well in school. Hope they enjoy it. It's a good thing that you reached some kind of an agreement on where they go, all right?
Thank you.
Good luck. We'll send you notice. Thank you.
Thank you.
That was unsatisfying.
I'm sorry.
No, I'm not complaining, all right? I mean, you guys are so close that you should be able to figure something out.
Well, we did, and there was a whole lot in there that we hammered out. We changed our schedule completely. We went to the Eaton County holiday schedule. We have the summer schedule. Like I said, it's
Just keep talking. I'm talking to them about it and try and figure something out before we end up in here. You won't be back till Thanksgiving, okay? So keep working on it, all right? Keep figuring something out that works for everybody. Thank you. Good luck. Versus Mr. Brown. We also have on the screen Miss Michelle Smith-Lowe from the prosecutor's office. This is a child support case that was filed by the prosecutor's office. Mr. Brown has filed a request for temporary relief, had failed to notify the prosecutor, who is still, this is still their case. We notified the prosecutor, who said she'd be on anyhow. I don't know that you will have much of an issue, but I appreciate you being here because it's still your case. So, this is father's request for some type of a temporary order. Or what are you seeking? You want, it says you want 2 weekends a month. So in other words, every other weekend and 2 weeks in the summer?
Yes, sir.
Miss Allen, at least on a temporary basis here, but, do you have any problem with him having every other weekend?
I don't have a problem with Jamal having every other weekend.
All right. So, when would it start? She's 7 years old this week. How about next weekend we start it?
It can start next weekend. That's fine.
What kind of times? Friday at 5 till Sunday at 6?
That can work. Yes.
Does that work for you, Mr. Brown?
Yes, sir.
This is the first one today that's been easy. Thank you. Friday 5 to Sunday 6. Is there any problem with, normally the transportation would be Mr. Brown would pick up the child at the start of his parenting time. You would pick up Miss Allen when you're supposed to get the child back at 6. Is that a problem with anybody?
No, sir. Not on my end.
No, sir. It's not a problem.
All right. We will also allow Mr. Brown to have 2 weeks complete in the summer. It will include his weekend, okay? So whether he starts it before or after, he'll have 7 overnights with the child. Sir, you must notify her 7 by May 1 of the weeks that you choose, okay?
Yes, sir.
2 weeks. Summer. Notify by May 1. That's each year, okay? Notify her what the weeks are that you want. If there's a dispute, in other words, if you pick this week and she says, wait a minute, I've got family plans on that week, all right? In the even number of years, you get your, Mr. Brown, even number of years, you get to pick, okay?
Yes, sir.
In odd, if she says, wait a minute, you gotta change to a different one. I mean, she can't pick the whole summer, but in odd number of years, you, she gets preference, okay? Does that work for both of you?
Yes, sir.
Your Honor, I do have a question. Once he filed the motion, I did put in a response attached with a police report for when he picked up the child with a loaded firearm. And a lot of the things that were on the police report, I wasn't advised of until I actually read the police report. And from what I'm seeing is that, like, this is child endangerment.
Well, Your Honor, since she brought that up, I can actually speak on that.
Hold on
She's
first
talking.
for a minute. Hold on. Are you done with what you want to say, Miss Allen?
Yeah, it's just the.
I understand your concerns. Okay,
Yeah.
I'm not. But I mean, Mr. Brown, this is your child. Obviously, if you endanger the child, if that kind of stuff, and she files a motion, I'll make it supervised parenting time. Okay, you understand? You gotta keep your child safe.
On the subject of she is speaking about in 2020. One second, can I grab the motion that she filled? There's her response, so I can actually tell you about what she's talking about.
There isn't much to get into because right now you're getting this parenting time. Okay, she's
Yes,
agreed to it. I'm just, and I understand her concerns. Okay,
yes, sir.
you should have those concerns, and if you think they're inappropriate, then you're not on the real world. Okay.
No, sir. I believe they're appropriate. I just feel like she's trying to use it in misconstructs. When I got arrested, it was my registered pistol. I just forgot to put it in my trunk.
Look at, that's not a very great excuse. All right. Firearms are dangerous. Firearms cause all kinds of problems. The biggest one is death. And
it wasn't in reach of the child of Nova.
I understand, but it shouldn't be around the child. Your firearms have to be locked up, have to be appropriate. There's a law now that if you violate that, you get in trouble. Miss Smith Lowe works for the prosecutor's office. Okay. And if you are found, she has allowed you to have this every other weekend, and there's nothing in it other than you must keep this child safe. All right. Then you can't be around firearms. Be smart. All right. I assume you don't want anything bad to happen to your child any more than Miss Allen does. So I'm giving you the opportunity to just be a good dad. All right.
Yes, sir.
All right, Miss Allen, I appreciate your concern. I'm not going to do anything. You've allowed this type of parenting time. It's appropriate. Maybe I'm assuming he learned his lesson, and that's all we need to do. All right.
Okay, so at this time, Your Honor, you're allowing for him to have every other weekend during the school time, and then also 2 weeks out of the summer. Is that correct?
He gets every other weekend all year long, but he also gets 2 weeks in the summer.
Okay. So I am okay with him having her every other weekend, but I was not okay with him having her 2 weeks out of the summer. That was the previous court order that we had in place. But once I did go down to the police department and I read over the police report, there's a lot of information in here that does bring concerns. Nova was with Jamal when he was arrested, and she has been affected by that, and she has voiced concerns. Nova has voiced concerns to me. She came back with that day. She came back crying, and she said, she explained to me what she saw. And my only thing is in that police report as well, it does show that his car was shot at in 2021. What if our child was in the vehicle when that happened? How do I know that's not going to happen going forward?
And you can't know anything is what is or isn't going to happen in the future. That happened in 2021. All right. I understand.
Can I speak on that?
Just a minute.
I'm sorry.
Just a minute. It happened in 2021. I'm not saying she wasn't scared. His parenting time for the summer doesn't come for a whole year, okay? It's after school is out next year, all right? And she'll have plenty of time to build trust and everything with Mr. Brown that it's not going to happen. If there is something that comes up, if he gets arrested for weapons charge or something like this, you can come back and ask for something to change. You agreed to 2 weeks in the summer earlier. I'm not minimizing your concerns, but
Yeah.
it happened 3 years ago. It'll be 4 years between when it happened, when he has 2 weeks in the summer. Let's see how it goes. All right. I'm going to order that at this time. If you think come next summer that it shouldn't happen, you can come to the court, but you better have something really specific and recent. Okay.
Okay. I was just unaware of this information prior to this case. I was unaware of this information.
Ms. Lowe, is there anything you wish to add? I can't hear you. You're not coming through. I can see you're talking, but it doesn't.
Have concerns.
I can sort of hear you. You too have concerns.
I mean, Miss Allen actually articulated the concerns we obviously have, the safety concerns that we obviously have. Mr. Brown kind of derailed our case in some way by filing this motion, but we can still proceed with child support. And I believe that this is still set for a pre-hearing conference with Mr. Hahn on August 20th. Actually, it was set, but Mr. Hahn was out of the office ill, and it will be rescheduled. But I want to just state on the record that we do have some concerns. The police report indicated that while this child is 7 years old, the police report indicated that the firearm was tucked inside the front of Mr. Brown's pants and that it was not registered. So we do have some concerns, some safety concerns that I want to place on the record regarding that.
I think I've addressed that. I've said that I have concerns too, but that doesn't keep him forever from having parenting time. He's going to have every other weekend, which mother agreed to. He will keep the child safe. I don't think he needs to be warned more times that if that happens again, I mean, if they pulled you over and you had a gun and the child and stuff like that, your parenting time would go to supervised. But I don't expect that. I'm assuming, sir, that you understand what is expected of you as a father.
Yes, sir. I definitely understand. And I've been on the straight and narrow since I've been home.
All right. So
does this begin, Your Honor?
What?
When does this begin?
Next weekend.
Okay.
All right.
Your Honor, if I may speak.
What?
So I understand that, you want to grant this parenting time, but who's to say that the next time won't be the case where the car does get shot up or it results in death?
Who's to say that something bad won't happen at your house? I don't.
Your Honor?
Well, wait, Mr. Brown, I'm fighting your fight for you. I don't know what you want to add. Okay.
I just wanted to state when my car got shot up, I was driving down the street and I was an innocent bystander. It was the summer when everything was getting shot up.
Look, we all understand that it was not a good situation and you shouldn't be carrying guns around. And if you get popped for carrying a concealed weapon that is not registered and all that kind of stuff, it's not going to go good for you. I'm saying that happened in the past. I can't predict the future, ma'am. I can't predict anything. I can't predict if you're driving along and somebody is shooting at somebody else and your car gets hit. Okay. I don't know that. I'm assuming that Mr. Brown is going to keep your child safe. If you find other incidents that cause problems, then bring him before me and I'll look at changing parenting time. Until that time, this is the order of the court. He will start next week, Friday, and we'll pick up the child. He is responsible for the child's safety while he's got the child, and actually always. All right? Both of you. Good luck. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Both parties are present with their respective attorneys. Mr. Krupp presents the defendant father, Mr. Buskirk, and Ms. Quist represents the mother, plaintiff, Ms. Buskirk.
If the court please, I have a suggestion.
Oh.
There's a lot of issues in this case. I would ask the court, because the time is of the essence, of course, there's about 9 or 10 issues, either refer it to the front of the court or set it for a trial on the issues.
Hold on a minute. Maybe first place, there's a request for entry of the child support order. There was a complete agreement with his attorney at the time to that child support order, and I think it's appropriate under the court rules. That was agreed to as well as the attorney fees. I've got the statement right here that his attorney agreed to it. I don't care that he now has another attorney. That's something he can take up with that. That's the first issue, and I don't know why I wouldn't enter it.
Well, my client claims he was never contacted about that at all.
Well, yeah, that's now that's easy to say, but here, the attorney has a clear agreement.
I agree.
So we're gonna enter that child support order, all right? Now, as far as the specific parenting time, we may have a lot more issues on that I'll probably have to set for a hearing or send to the friend of the court.
We would agree to that.
I saw Mr. Buskirk's response. Ms. Quist, I've read your motion. I mean, there are some things in there that are clearly, when I looked at his record, it doesn't appear that he's had anything for the past 7 or 8 years.
That's wrong, Your Honor.
Hold on. There is no, and
I agree. On the contrary, though, we do have a video of him drunk in July of 2023, and his own sister says he was drinking again, and she should know because he lives on her property. We have an autistic child here.
I understand, but then we're also talking about a year ago.
That's true. I agree with you. I think we should start out cautiously. I would ask that this court order some co-counseling with Carmen Furman, who is the counselor for the minor child. He's autistic. He hasn't seen his dad in a year, and he hasn't asked for parenting time in a year. A few questions there. I think
he denies that. He denies that, and that's where I'm starting to run into problems, is because one side says, I mean, I don't know. You say basically he hasn't seen the kid for a year.
He hasn't.
And he says, yes, I have. Now, how do I do that on a Friday morning without having an evidentiary?
Where's your lie detector test?
Well, I got that. I got that right here.
Judge, set it for trial or in front of the court, please.
Sure.
There's too many issues to resolve on a Friday.
Well, you're right, but if I send it to the friend of the court and you guys don't agree on it, then I have a hearing anyhow. So maybe I should just have an evidentiary hearing.
Let's have a trial.
Let's have a trial. Your Honor, we're not, time out, everybody. We're not disputing that he should have parenting time. They did not request that any of the conditions be removed of his parenting time. I'm saying, let's start parenting time, but let's start it with a therapist. Why wouldn't we do that when we have an autistic child? And we have an autistic child who hasn't seen his dad in a year. Let's say that he says he has. Well, according to this kid, he hasn't. Why wouldn't we send them to his therapist so they can get reacquainted and have a healthy and productive relationship?
You guys can agree on them in the meantime, but quite frankly, he says he's seen the child. You say he hasn't, okay?
He hasn't.
I understand, but you sit here for a minute and tell me, did he or didn't he? He says he did. All right.
I know you don't have a lie detector test that you can hook everybody up to on a Friday morning. I discussed that with Ms. Hornis, that it is a problem on a Friday morning motion that you don't have any way of determining whether or not these people are telling the truth. What I'm saying, I'm trying to propose a path forward. If we start with some co-counseling, whether you set it for a hearing or not, the father can get reacquainted with his son or just better acquainted, whatever. Why wouldn't we do that with an autistic child who's not used to things being out of order or chaotic? They don't do well with change.
I'm not going to do anything with parenting time. I'm just going to set an evidentiary hearing.
What is the evidentiary hearing for, is my question.
Because we have a tax dependency issue too. She's not working, so he should get the tax dependency. A trial will solve all these issues.
Not in the judgment at all. I'm just going to leave it up to the IRS like it always has been.
Yeah, but she's not working.
Your Honor, for a path forward, I'm proposing that they start out, he lives 73 miles away, one way. So that's an issue. He lives on his sister's property. Ms. Hornis is in touch with his family, and they are willing, his sister is willing to provide supervision. I just want him sober. I want this kid safe. I think that fathers and mothers should have a strong relationship with each parent. I want it to be safe. I want it to start out maybe a little bit slower, but it's not like I'm saying 6 months. It's not like I'm proposing over the next year. We just want it to get started. We want it to be safe. We want it to move forward. I'd like for him to go to counseling with his son. What's wrong with that? And then very
Talk to
quickly,
Mr. Krupp about it. I'm not gonna make any parenting time order, other than I'm gonna have an evidentiary hearing regarding parenting time. I don't know whether or not he's seen his kid in the last year or not. He says he has, you say he hasn't. I don't know what his relationship is with the child. We're gonna have an evidentiary hearing,
Okay.
just because there's nothing else. If you and Mr. Krupp can come up with a way to, hey, yeah, why don't you do this and do that? That would be wonderful. But you know, that's gonna have to happen. The child support
Okay.
order will enter. I don't, we'll leave the tax exemption up to the IRS, because there's nothing in the judgment at this time. If you want to renew it at a later time when we have our hearing, Mr. Krupp, for parenting time, if you want to renew that motion and
Thank
provide
you.
some information, you can, but at this point, the IRS makes the determination, because the parties didn't make the determination in their judgment. They basically left it up to the IRS then.
But she isn't working, so she has no reason to have it.
Yeah, and she says you don't, your client doesn't see the child either. So leave it up to them, and maybe you can talk to Miss Quist if it's beneficial to the family that he gets it next year. Talk about it, okay? I said you can bring it up again if you want at the next hearing. We'll get in touch with both counsel to determine a time when you can do it. It won't be till November, is what I understand. But good luck.
Thank you.
Thank you.
Thanks, Judge.
Thank you, Judge.
Everybody have a good weekend.
Everybody have a good weekend, but make sure I get the child support order.
Yes.
To me, okay?
And we have it. It should have been attached. Well, we'll send it right over to you. Thank you.
All right, thank you. Thank you. Versus Johnson. Mr. Johnson is present, as is Miss Johnson, both via Zoom. This was a motion by Father to clarify genetic testing. There was on 6/28, I believe there was a motion that he had brought. And in looking at my notes, it said she had 1 week to complete testing for genetic testing. However, when the order went out, it was our standard order that we prepared. And it says 60 days per the court order. Ms. Johnson, when are you gonna get the child for genetic testing?
I was told not to do the genetic testing right now because there is a CPS case going on with a detective
The court
involved.
ordered you to do it. Who tells you not to?
The CPS worker and the detective, because it was showing neglect on his side, and she also told me to give you her number.
It shows neglect on what?
On his side from when he
That's
had it.
What do you mean? Hold on just a minute, because I don't want some CPS worker telling you not to follow a court order.
That's not true.
End of story. I mean, why shouldn't he be tested to determine if he's the father?
You have to ask her that, sir.
Well, I'm telling you that you got to have the child tested. You don't have to be there at the exact same time as him or everything like that. I don't know that's what you're worried about, but I want to know if this child is Mr. Jackson's child. You can deal with that afterwards, no matter what, okay? Whether it is or isn't, and I have nothing to do with the CPS case. There's no abuse and neglect case apparently filed with the court. I'm just trying to determine if Mr. Jackson is the father. And I can't imagine CPS doesn't want to know if he's the father or not.
Yeah, they don't want her back in his care.
That has nothing to do with it. Nothing. It's just determine if he even has legal rights. He doesn't get any care of her right now, okay? But we can't even determine, he may never get to see her if he's not the father, okay? If he's not the father, he has no rights, period. All right? And if he does, then you can deal with it in CPS. You understand that?
Yes.
Just having him determine whether he is the father or not, that's only the first step. Now, the order that you got did say 60 days. Did you get that order?
Yes, I did.
All right. I'm going to issue another order that you got 10 days from today to get the child for genetic testing.
All right.
All right. It has nothing to do with any time that he spends with the child. I can't give him time with the child until I even determine if he is the father of the child. You understand that? And then if he comes in and says, I want parenting time, that's a different world. Then we'll deal with CPS and everything. All right.
Yes, sir.
So basically you have, it's actually through Labor Day. I want the child tested. That's all. And it takes them time, once he's tested, to actually determine if he is. They got to run the tests and they got to submit a report. And then we'll see from there, right? There's really, it's trying to determine if he's the father. Then it moves on to something else. Who's your CPS worker?
Her name is Leah.
Leah?
Yes, Leah. I got her number too.
Give me her number.
615.
All right. Well, I'm telling you right now, when Leah tells you something, you do not violate my court orders because she doesn't want to determine if he's the father or not. It has nothing to do with whether he has time with the child. He's a putative father and he is supposed to determine if he's the father. Okay?
Yes, sir.
He doesn't have any rights until that is there. And I'm not going to say at this rate, he'd never have rights. Mr. Jackson, you can submit in there within this week to DNA testing.
I already did the DNA testing, sir.
All right.
That's
So
what we was waiting on.
So they have your DNA.
Yes, I did this like a few months ago.
All right, ma'am, get in there. What is the place that you went to?
It's off of Michigan Street, I believe. I forgot the name of it.
Well, she's got to go to the same place.
It's the one that's set up through the courts.
All right, ma'am.
Yeah.
It's one that's set up. Get there. All right. I just want to find out if he is even father. This week.
Yes, sir.
Thank you very much. Sir, we're adjourned. We'll get her there. If she doesn't come back, then I'll hold her in contempt.
All right. Thank you. Appreciate it.
Do anything with legal custody.
I didn't think so, but.
I want to call that Leah.
Yeah, she didn't say that, Your Honor. She didn't say that. They actually came to me about an open case with her, and they said they know that she's been with me, and they said my daughter have a new open case with her since she's been with her for the 2 months.
All I'm saying is I want testing done. You've got it done. I want her to get testing done. All right.
Yep.
Thank you. I'll do my best. Thank you. You can log off. Number nine. Hey, you know what? That's on the White Album, the Beatles' White Album.
What?
It's on the Beatles' White Album. I think that's what it is, and it's called Number 9. Are both parties present?
I'm not expecting the other party to join.
Sir, all right, we're here in case Dahlberg versus Dahlberg. Mr. Dahlberg filed a motion. Does she know about this motion?
Yes, I mailed her her copy that she should receive, and then I called and informed her of it, and then she
When
should
did
have
you mail
received
it to her?
right the day I filed it.
Go back on 8/2?
Yes. And I provided her email address to be notified to receive the meeting.
And you've talked to her about it?
I have.
Well, you basically said the parties have agreed to you having full custody, right?
Yeah.
Then why don't you guys just do an order, a stipulation in order? You can get it down here and fill it out and say the parties agreed to Dad having, I mean, she's in Alabama?
She's presently living in Alabama. I did go to that legal services group at the courthouse, and they instructed me that this is the process to follow.
Well, see, here's the process to follow. If you agree to it, you both should write it out and agree to it. Okay. Otherwise, I can't change custody on a Friday morning. Okay. I have to, in effect, say it appears that she has left and apparently doesn't have much time with the 2 children. She lives in Alabama, and I know it may sound crazy to you, but I got to have a hearing to determine custody change. That's what the courts tell me, even in this type of situation. I'm required to I'm clearly find the first thing that needs to be found, which is Vadvarka, proper cause or change of circumstances. The parties did have 50-50, as I understand it, but she has now moved away to, and is ultimately in Mobile, Alabama. Okay. And so it's obvious that you're not having 50-50, that you have the kids basically full time. All right. Yep. So you have met what's called proper cause or change of circumstance to have an evidentiary hearing. It seems like it would be logical that I would give you full custody here because she doesn't, but I can't. I'm just not allowed to by the law. Okay. So I will set an evidentiary hearing on it. In the meantime, you guys should reach an agreement and sign something and send it into the court that says, yes, Travis will have custody, I'll have parenting time or whatever, at such and such a time. I'm going to suspend your child support or abate your child support right now because clearly you're paying child support to somebody who doesn't even see the children, okay? And we can deal with that issue also, but I think I should suspend your child support because money's going to her. And how long has she been not seeing the kids?
They've been living, well, the older one's been living with me full-time since January. The younger one full-time since March. She moved away to Arizona in April and has since moved to Alabama. And she's seen them once. And
okay, and that's why I say you clearly meet Varka, okay? And it's hard for me to sit here and talk to you and say I got to have an evidentiary hearing, which probably won't occur till November, to change custody. But quite frankly, I'm just not. I mean, the Court of Appeals and everybody tells me I can't just do it on a Friday morning. If the two of you agreed to it, I can do anything like that. Okay, I can follow your agreement, all right, and would. But until then, I just have to have an evidentiary hearing. We'll set one up as soon as we can.
Okay.
I'm assuming that the address that you have for her, and I'm not going to read it because I think we're on YouTube.
Yeah.
But is the correct address 4358?
She provided that to me. I don't know how permanent of an address that is.
Okay, but I mean, we can certainly mail her notice there.
Yeah.
Talk to her and just see if you can't get some kind of an agreement. Otherwise, we got to come into court and, you know, you're going to get a whole thing of what you have to file ahead of time, a brief and all this kind of stuff. And it seems kind of crazy. Is she planning on coming back?
I don't know. It's kind of, I don't know. I mean, she moved to Arizona and then out of the blue, she told me she now lives in Alabama. So,
yeah.
I'm not expecting her to in the near term. Who knows what the future brings? But so had she been here, would this been the proper venue or forum?
You would still do exactly as you did.
Okay.
And I'd still tell you, why don't you I gotta set an evidentiary hearing for it.
All right.
But why don't the two of you get together and agree on what you're agreeing on?
Okay.
Send that to me and it avoids everything. All right. I mean, I can't imagine that she's going to fight you having full custody since she isn't even around.
Mm-hmm.
Right. And, you know, you can agree on some kind of parenting time for her or whatever, but it sounds like, I mean, you have custody now because you both have custody. Okay.
Mm-hmm.
So, you know, if she comes back and suddenly wants 50-50, you might want to file something else to deal with that. But as long as that doesn't happen, we'll set up a hearing as quick as we can. We're probably going to set something. I might try and set it a little earlier, but a very short time, assuming that what you're saying is going to expire. And then make sure you're here and ready to go.
Okay, so we'll set a new hearing, but in the meantime, try to get an agreement submitted to you.
If you can get an
ahead of
agreement,
time.
great. Otherwise, come in on the time and look at the notice and try and follow the notice, what it requires, okay? You're like a trial brief and this kind of stuff, if it's gonna come down. That's why I'm saying it's too bad it's gotta go to all that kind of stuff for something as simple as this. But I just have to do it.
Yeah.
Not, it seems crazy, but I have to do it. All right. So good luck. I will contact the friend of the court as far as abating your child support as of now.
Okay.
You are paying child support, aren't you?
I have not last few months since she moved away. I mean,
you have a child support order for.
I have a child support order, but I didn't pay her for when she hasn't had any.
Does it go through the friend of the court?
It does not. I've been paying her directly, and then after she moved away,
all right,
I didn't pay her for it.
Well, we'll issue an order that says child support is suspended.
Okay.
At this point, okay.
Okay.
All right. Good luck. We'll see you. I hope you can figure it out, but otherwise, we'll see you relatively soon.
All right. Thank you so much.
Thank you. Good luck.
Bye. Bye.
Suspended as of today.
Yeah. No, it's suspended as of, where are we in the month? August 1. 9. Have you ever listened to the Beetle White Album? No. That should be something that you should sit and listen to this weekend. You'd be amazed. Matt Reams can't hear us yet, can he? Because I'm gonna.
I may be able to hear you. Good morning.
Good morning, Mr. Reams. Good morning, Mr. Schaff and Miss Barrios. Can you both hear me? All right.
Yes.
All right. First, Barrios, both parties are present via Zoom. Mr. Reams represents Mr. Schaff. This is the father's motion for entry of a child support order. It is only a temporary order, as I understand it. At this point, there is no final custody order and things like that. The friend of the court has done a recommendation. Miss Barrios, what's your objection? It seems appropriate to enter this now. It can always be modified at the completion of this. You can take into account something at the end of this, but it appears to be appropriate now. Is there any reason why I should not? Can you convince me why I shouldn't enter this order?
The orders are very temporary in regards to the child care. How we have it structured right now is I'm only getting a supervised hour, which doesn't necessarily, it is subject to change based on what we do moving forward in the temporary order. Additionally, some of the numbers don't really make sense as to what I actually make as far as my income. I'm willing to split whatever I need to. I'm willing to pay in the interim of him having her for the time that he does have her. I'm just not agreeing to the amount that it is at this time. I do not make what the numbers make up to say.
Well, the friend of the court did an investigation. They also took into account something that you filed recently about what you do make or whatever. This is a temporary order. Mr. Reams, is there anything you want to say other than what's in the motion?
All I would say is that the court has keyed upon what the friend of the court did, which was they simply looked at the employment contract that she submitted as an exhibit to her last motion. So I'm not really sure how the income could be disputed. Mr. Schaff is simply asking that the recommended order be entered. I would note, Your Honor, that the number at 660 is actually low because they gave her a 2-child adjustment, even though she doesn't have a child living with her and she doesn't pay child support for her either or 2 children. So the actual number is 806, but we're not asking for that. We're asking just that the recommended order be entered.
Well, and you, Mr. Reams, you fully understand that this is a temporary order. At the time of completion of whatever it is, the court can make appropriate adjustments to this if it was too much or too little. I suppose the court could make appropriate adjustments. But at this point, ma'am, you just admitted that you get 0 overnights. The money seems to be appropriate. At this time, you mentioned something about childcare, but there's nothing in here about childcare. I don't know whether or not Mr. Schaff has childcare expenses or not. He does not. You don't have overnights, so this appears to be appropriate as a temporary order at $660. When did the friend of the court do this evaluation and send it out? Because that's when it'll start.
The recommendation was ordered on 7/11 of 2024, so I think the first charge date would be 8/1.
Are you all right with 8/1? Because it was referred to the friend of the court, though, wasn't it?
It was referred to the friend of the court via an order from 7/11 of 24 that had its origin in our motion for temporary order, which was filed in June. So again, the date of entry, or rather the date of effectiveness from our perspective, would be fine at 8/1.
All right, make it effective 8/1. All right, and we will enter that order. I know there's one in here, but I'd like you to give me an order that is comports with this, and I'll enter it.
We'll submit it, Your Honor.
And Ms. Barrios, you again have to understand this is temporary. We got to get something going. It's effective 8/1. You're not all the way through the month yet, but you owe $660 for August, and you'll owe $660 for September and whatnot until something is changed. All right. Good luck. Thank you very much.
Thank you, Your Honor.
Good weekend, everyone.
You too.
Wonderful. This is the last one. DS is matter of Steimel versus Hanselman. Both parties are present on Zoom. They are both represented. That being the defendant is represented by Miss Robron and the plaintiff by Miss McClure. there are a couple motions here, basically. One, the father has filed them. One is for a change of parenting time, and another is for a change of schools, if you will, asking that the children be allowed in Plainwell. Why don't we deal with the parenting time motion first? Ms. McClure, I mean, I know you say that she doesn't exercise all her parenting time and stuff like that, but what are you asking for? I mean, what, you want to eliminate her every other weekend or what?
No, Your Honor, I'm sorry if I wasn't clear enough about that in my motion. What we're asking for is to eliminate the optional extra weekend. So their order contains the alternating weekend schedule, which we're not asking to change at this time. We're just asking that optional extra weekend that would essentially give her a third weekend in a month, that be eliminated. Ms. Henselman has never practiced that. She's never.
But the optional weekend, at least before, had to be exercised within like 15 miles of Rockford, right?
Right.
And I don't know why I would change it other than to say it has to be exercised within 15 miles of Valley. All right, if she wants to come up. She's got to give, how much time does she have to give notice? 2 weeks or something? Or she has to give some kind of notice. Can't just show up on a Friday and say, hey, here I am.
Right. Well, I think the point is, yes, she does have to give, I think it's 10 days advance notice. Again, it's hard to remember because it's 14 days advance notice. I think the point is that it would be extremely disruptive to the children at this point because they have never had to do that. There's a lot of resistance to even going. And so that's why we're asking for that to be taken off.
I mean, Ms. Robron, you can say if you want it off or not, that's fine. I don't see a reason necessarily to do anything to modify it because she on her own has said it's really expensive and I can't really do it. But if she chooses to do one with 2 weeks notice, I can't see that it's going to be any awful. The only change would be that it must be within 15 or whatever you want to say, 15 miles of his residence in Allegan because he's clearly moved there. Okay. And I don't want to make it 15 miles from Rockford because that doesn't make any sense. All right.
Understood.
Ms. Robron, I didn't require much of you for that one, but I'm assuming that unless you want to give up that optional weekend, in which case you guys can stipulate to it.
No, Your Honor, my client would like to keep the optional weekends.
We'll let it stay for right now. All right.
Thank you, Your Honor.
Because she has to give 14 days notice also. Okay.
Correct.
So, and I understand that she has to come up and probably drive up and get a hotel room and spend the days and it's really expensive. And I don't know that she has that kind of money to do it, but she has the option. It was what they agreed to. And I don't see anything that has changed to warrant a change of that. Now, the second issue is much more bothersome to me, which is the schools. Okay. I know what they're asking for to be allowed to enroll the kids in school there. I'm well aware of the law that says I need to have a Lombardo, and I know that Ms. McClure understands that and everything, but we're at a point now where, I mean, you're Ms. Robron, you're constantly saying, he moved down there to be with his girlfriend and to live with his girlfriend and stuff like that. If you look at case law, parents often decide to move for reasons not solely centered on the educational needs of their children. Unemployed parents find jobs in distant locations. Single parents meet potential spouses. The Court of Appeals doesn't find that that's such a bad thing if he moved down there for that. I'm reading it right from Zalewski versus Garrison. I'm trying to figure out what you want, Ms. Robron, because what you want is to have the kids go back to Rockford, a place where she is nowhere near Rockford. Does she want to transport them on 2 of the 5 days to Rockford schools and back?
No, Your Honor, she's in Indiana. The issue here is that he unilaterally moved without consideration of what it would do
He's allowed to move, and don't get into that. Unilaterally, He can move anywhere within the required area. He can move there. So go ahead.
What he can't do is change their schools without consent or an order of the court.
Yep.
And he doesn't have either one of those right now.
And so your client is asking for him to drive the kids back and forth to Rockford so that when we have a hearing, I'm going to say that is absolutely ludicrous. I mean, seriously, are you going to come in and argue at the Lombardo hearing that the kids have to maintain their school in Rockford? because she doesn't know anything about Rockford. She doesn't live there. She's never been anywhere near there. He actually moved towards Indiana. Okay? So is that going to be your position, that you're going to come in and say, yes, because that's fine. If you want the kids to remain in Rockford, I'm going to make her responsible for some of the transportation to Rockford. Why not? Why shouldn't I?
Okay.
So is she going to be responsible for the transportation?
At this time, Your Honor, I would like Ms. Hanselman to be able to speak up. If she is willing to do the transportation, then that's what we will ask for.
Ms. Hanselman, are you gonna transport the kids to and from Rockford School at least 2 days of the week?
I won't be able to, Your Honor, because of my job.
Well, he can't do it either because of his job.
My main thing is that it wasn't my way for the boys has to go to Rockford. My thing is since he's moving to.
He's moving what?
He's moving to Allegan, is that the children should be homeschooled because that way we can have equal amount of time with the children.
You're asking for a change of custody. You have no Vidvarka or proper cause to change custody. Because you're asking that each of you is going to do 50% of the time. There is nothing there for that. Counsel, you have nothing as far as that goes. Or at least you haven't pled it or you haven't asked for it. Because she's asking, I want 50-50 time so I can homeschool the kids.
Well,
I get that. Ma'am, no, I'm talking to your counsel now.
Understood, Your Honor. We're just asking that this go through the proper channels, or at least that the plaintiff include my client in on this decision making. He goes and he makes these decisions without considering what Ms. Hanselman wants for the children as well. So he moves, he changes schools, and then he basically just tells her to deal with it.
I'll set up an evidentiary hearing, a Lamardo hearing, because I've just told you, I don't know what you're going to present that says, you know, the kids got to go to Rockford. I'll set that up. I'm tempted to, at least right now, to allow the kids to go to the school in Allegan pending that hearing. And if I find that the kids should go to Rockford, they'll be transferred right there as soon as I make that hearing. But you're asking for him to transport the kids an hour. You know where Rockford is, you know where Allegan is, okay? You know he's got to drive up 131 and take the kids there and bring them back, and I don't know how he's going to maintain employment. He's allowed to move, okay? End of story. He doesn't need her permission to move, all right? At all. He's supposed to get joint legal as far as change of schools, but your client, if she was living here, even in Cedar Springs, and said, no, I want the kids to continue at Rockford, we'd have something to fight. But she's asking for a change of custody. She doesn't qualify for it. So, and you know, this stuff, she talks about him like, yeah, he moved for his own sake to live with his girlfriend or something like that, which is permissible. And then she goes on and says, no, the 16-year-old can't get a job unless it's down here because I don't want it affecting any of my parenting time. Even though that's ridiculous, because if the kid gets a job, how's he going to do it part-time? He's not going to be able to do it during the school year up here. He's got to, you know, I mean, she is selfish also. Clearly. She didn't want him to do driver's training if it interfered with, that's the kid. All right. She wants to claim everything for the kid. All these poor kids, I want to do that. But she is as selfish as he is.
May I clarify?
You may clarify.
On the job perspective, Ms. Hanselman asked that he work when he's with the plaintiff, and then she also tried to get the child a job in Indiana so he could work both places. That was the intention. She was trying to work with plaintiff on that. As far as driver's training goes, she just asked for makeup parenting time if the driver's training was going to be on her time. She's not trying to prohibit the child from going to driver's training. She just wants to make sure that it doesn't impact her time. She was trying for makeup time. These individuals have an incredible difficult time communicating with each other, creating a ton of issues here that we're trying to work out. Bottom line is that we need to get some clarity, and the plaintiff needs to understand that they have joint legal custody. These decisions need to be made together for the best interest of the children.
Well, you know what? Maybe what we should do is determine whether we should maintain joint legal custody. If they cannot agree and all this kind of stuff, and I don't know about this idea where she wants the kids to be transported to Rockford when she has no alternative other than to go to Rockford, that she has, other than to say homeschooled with, at hers for 50% of the time, which is, come on. She hasn't filed anything for change of custody, and nor does she have the ability to, because I don't know what she would meet with Budvarka. I mean,
No, understood, Your Honor.
You can't be blind to this kind of stuff.
Understood,
She
Your
can't
Honor.
transport the kids, and he says, I can't transport them that far. I'll lose my job.
Yep, a homeschool came up because that was something that the plaintiff had presented and something that the defendant was interested in. If that is no longer the case, we'll pursue different avenues.
So what do you want the order to say today? You want me to order, because I don't think I'm gonna, that the kids are re-enrolled at Rockford and are transported there until we have a Lombardo hearing, which at that Lombardo hearing, it seems, tell me what you're gonna present that would make it for the kids to continue to go there. They won't be near any, they'll have friends there for the time being, but once they start, they'll be leaving Rockford every time right afterwards. They won't be able to have kids that they'll do with. What about extracurricular activities, stuff like that? What are they gonna do? They aren't gonna be able to do all those. They got 4 kids, don't they? 4 kids in Rockford. And are you really thinking that it's appropriate that he transports those kids up there, brings them back every day, and does it? She can't help out at all.
Understood, Your Honor.
Well, I'm asking you, what do you want?
We want to be able to have an equal say. My client wants an equal say here. I think at this point, if the court is inclined to allow them to enroll in Plainwell schools on a temporary basis until the parties can get to mediation to work out these issues and fine tune some of the things, I think that would be the most appropriate.
We are going to set a Lombardo hearing because that's your request, okay? And if the parties want to go to mediation, that's fine. Ms. McClure, what's your thought on that?
Well, yeah, so she's requesting a Lombardo hearing. She's entitled to one, Your Honor, and that's clear. We are theoretically open to the idea of mediation. And I think I said that to my opposing counsel. In lieu of this hearing today, we were willing to attend mediation if they agreed to temporarily allow us to school. But
I don't know why parties would ever not accept mediation.
Right. So I just want to say that the 2 youngest children are going to have to change their school. No, but regardless of what the court orders today, the 2 youngest children, they were in the school of choice elementary school. They cannot get back into that school. That ship has sailed. They will be changing schools regardless of what is ordered today. My client has also learned from Rockford schools that they will not accept a school of choice application from him because he lives out of county. So he's too far away he would have to somehow prove to him that he lives within Kent County, which he would have to either lie or actually move back to Kent County in order to get them re-enrolled in Rockford.
Well, look, you're going far afield because they've even acknowledged that I basically probably and will order that they be allowed to attend the Plainwell schools until we have a Lombardo hearing, all right? Because at that Lombardo hearing, if for some reason it says you got to enroll them someplace else, they will be enrolled immediately someplace else, okay? This is not best for the children because I hate to pull them out of schools and stuff like that, but she's entitled to her hearing if she wants her hearing, and you know that, all right? I'm only dealing with the reality that says, I'd ask others around here, because I don't know what happens with the schools if you don't live in the district. I don't know if he lived in Rockford and was in the Rockford School District and they were going there, if now he lives outside of it and they say, wait a minute, you don't go to this school, or can they maintain that indefinitely as long as they stay there? I don't know that. I don't know the schools. But the reality is I don't think there's any way he can transport him back and forth and maintain a job, and she can't help out at all. So yeah, the reality is he's supposed to talk to her and make some kind of decision. But if we're going to get so far afield of that, I'll have an evidentiary hearing on whether or not we should maintain joint legal custody. If these parties are just not going to be able to agree on something as simple, and what I see in this case as simple as this. To me, I'm going through this and I don't understand why this is any kind of an issue anyhow, but we'll have it. So with that, I will deny the parenting time request for change of parenting time. I will You may enter an order that the children may temporarily be enrolled in the Plainwell School District pending a Lombardo hearing. Other than that, I guess everything remains the same. But your client has to understand that if for some reason I find that Plainwell is inappropriate, the kids are going to be moved.
We have no doubt that the court will find Plainwell Schools an adequate school district.
Well, I don't know. Ms. Robron, any statements you want to make? I mean,
No,
technically, I'm not supposed to let them move until I have a Lombardo hearing. But I'm here today and kids start school Monday and we aren't going to have a Lombardo hearing between now and then. All right. And because I can't get any rational reason why I would send them back to Rockford and no ability of mother to even begin to assist in that, yeah, it wasn't done right, but it was done with the realities of the world in mind. Send through that order. We'll send you a hearing date for the Lombardo hearing.
Okay,
Thank you so much, Your Honor.
Thank you. We're adjourned.
Thank you.
Mortimer versus Cuevas.
Yes, sir. Excuse me.
Parties are present via Zoom. Ma'am, can you hear me?
Yes, I can hear you.
All right. This is Mother's Parenting Time motion. There was a stipulation in order back in September of 2022 for parenting time. The parenting time says parenting time as agreed. That's it. And now she's complaining that she doesn't like what she agrees to, apparently. Which I don't understand your motion, because you don't have to agree to anything. And then he'd have to file a motion for it. But what do you want? You want specific parenting time?
I guess I didn't understand what I filed. My apologies, sir. I thought that I was obligated to give parenting time, so I'm sorry.
You are as agreed. That's what the order says. And if you don't agree, then what? You don't agree to have him come to your house.
Yes, sir.
What kind of, you want him to have parenting time, like what, at the Y or something like that? Supervised parenting?
Yeah.
Time?
Yes, I'm asking for that because of the toxic relationship that him and I have had because of domestic violence.
That isn't part of it. It's only what relationship he has with the kid. With the child.
I'm worried about the welfare of my child and his care by himself.
Well, Mr. Cuevas, what do you have to say?
Your Honor, like this is just become up just within the last week, or actually the last 2 weeks. I did make a mistake and introduced my daughter to another woman. And ever since then, this is just out of the ordinary. If you ask Kalina Mortimer that I drive to go see my daughter every day, I used to pick her up every day from daycare. My daughter loves me, and she knows that I haven't seen my daughter in 2 weeks because she's using this against me. She uses my domestic violence against me, which is, I think, I took responsibility and I'm paying like the price for it.
It's one of the very important parts of the best interest of a child, any domestic violence. And if it goes against you, it can severely injure your ability to have any custody. Go ahead.
Yes, sir. But I've respected every boundary. I go to Kalina's house, I have to drive almost 20 miles every day to go see my daughter. And that's like one way. I would go see my daughter every day. And I would do things
How do you see her every day? What do you mean?
Sorry?
You see her every day? What do you mean you see her every day? After school?
I would go spend time with my daughter every day. I would take her out of the house. I literally taught her how to ride a bike at 3 years old. And and it was like the most best thing that I could have ever done with my child.
Where do you live?
I live on the southeast side of Grand Rapids.
You have your own house or what?
I live in a transitional housing. I just completed a program. It was a 6-month program for alcoholism. I did relapse, and before I got worse, I put myself into a program, and I did complete it, and I do have a certificate for that. And I am back on my Vivitrol shot, what I've been on for 3 years.
Okay, but I'm not too thrilled about sending your child to transitional living home.
No, that's the reason why I used to go to her house every day. I brought her here. I brought her here one time.
She has the full right to say, I don't want that anymore.
No. I told her respect it. I never told her I didn't disrespect it or I didn't.
That's a lie.
Well, Yeah, I'm moving on from this. I gotta start today, okay? I'm not gonna make
Yes, sir.
you have to supervise parenting time with somebody who has been convicted of domestic violence against you. I'm not gonna make you do it. So that's it. So I'm trying to find out where or when he could see his child. Sir, give
Yes,
me
sir.
some options.
That's why
Because,
I'm asking the court. Sorry.
ma'am, has he been regularly at your house seeing the child?
Yes, and I found bottles of him drinking, smelling like alcohol, and with his things, it got me scared. And I've asked him to leave at times, and my daughter's at the point where she's telling him to leave when she hears us escalate, and that's not a safe environment for my daughter.
May I speak upon that? Like she's gonna always throw the alcoholism in my face. My support system, like I'm around other people, and yes, she did find a bottle. I had old clothes at her house, which she can understand and can attest to, and that I was going through. And there was a bottle that she found in the trash that I threw away. Was I drinking there? No, sir. Do I drink around my daughter? No, sir. Now,
Okay, it's clear from your statement, you have an alcohol problem. It's whether it's in remission or not. You have an alcohol
absolutely
problem, and I gotta protect your child until you can show significant alcohol-free time. All right, but I can't. Yeah,
I have a
6 months is not enough. All right. Yes, it's good. You got to take the first step. Okay, you do, and you can't be sober until you get through the first day, and then the second day, and then the third day. Okay, I understand that. I'm giving you congratulations for making that. All right, you just have to do that. All right, and that's great. And she is rightly concerned because this is not the first time you've fallen off the wagon, apparently. And so she's rightly concerned. I'm trying to find is there any other, sister, brother, aunt, uncle, where the child could go that he would be supervised, other than the YWCA, ma'am?
I don't have anybody in Grand Rapids. That's
I'm not
why
really
I want.
asking you, does he have?
Oh, sorry.
Yeah, because I'm not gonna force you to be the supervisor. You put up with enough. Sir, do you have somebody who can supervise parenting time?
No, sir. I actually do not hear. I don't have family also in Grand Rapids.
So then where are you proposing to visit your daughter?
Your Honor, may I also say another thing too? This isn't just about that though. I haven't worked in a couple months due to my surgery. And Kalina has been she's been pressuring me about money, which I can understand, but I have doctor's notes stating that I'm not even really supposed to be working right now. And she's been complaining to me about money and how she's having money problems. And this is the biggest concern. I don't even think it's more about the alcohol. This is
I'm going to send child support to the friend of the court for their determination as to what's appropriate. So that's done. I'm asking you, where can you visit your child other than something like Journeys or the YMCA where you're supervised? I'm going to make it supervised for a while because I got to make sure that you're not drinking and things. You don't even, it's not appropriate. You even acknowledge at your transitional home. So what are the options?
But
2 hours.
I actually have text messages from her, just the other day saying that, hey, we can meet at the park. We can meet at the park and you can see Anaya. So this is becoming absurd. You know what I mean? She's making statements that are untrue. I can actually physically show you off of my phone from her saying, hey, yeah, we can go to the park. We can go in public places and meet. You can see your daughter.
She's saying now to set up something different. She's here. She's saying that that's what she wants. All right. End of story. You can say that in the past, because in the past you saw the child a lot. Okay. And you went to her house and she said she's tired of it. All right. I'm not going to make her the supervisor.
Yes, sir.
So, do you want to meet every, how old is this child, ma'am?
3. She'll be 4 in January.
I mean, I don't know what to say. You want to meet at McDonald's Playland twice a week or something for an hour and a half or something, and you get to. You're not giving me anything, sir, to tell me where you can parent this child safely.
I understand, sir. It's understandable.
Ma'am, is there some place that you can think of that's like a McDonald's or a Denny's or something? Do you know what I mean? Something that's out in the open there that you would drop the child there. You don't even have to have contact with him really, other than he gets the child and sees the child for an hour or something, hour and a half. couple times a week? Is there something that we can do that? I don't want them coming to your house.
I don't either. There's a couple things they both like. They both enjoy the library. We could do a library, McDonald's. Those are fine for me.
And like, can you do it a couple times a week?
I could do it. I would have to do all the driving. But if you want to do it on the weekends, on maybe every other weekend, I can do it. And then on a maybe Wednesday night, I can meet up with him at a McDonald's. I could do that.
Sir, can you be there?
Yes, sir. Yes, sir.
Ma'am, you don't have a license, sir?
Yes, I do. It's just that she knows that my vehicle, I ran that vehicle down so much driving, you know, and she knows she had to follow me quite a few times from me going to see my daughter. I was taking chances like getting stranded to go see my daughter. And she's followed me a variety of times trying to get me home.
And I don't know what the purpose is of that argument. I don't know what it is. She thought every other weekend you could go for a couple hours to the library. What library?
The one in Wyoming across from the police station. It's the one that's by in Wyoming. I don't know the name of it.
You know where she's talking about, sir?
Yes, it's right there on Michael's.
Right on Michael? Oh, I think I know what you mean.
Yes.
Wyoming Library. And that would be 3 hours every other Saturday?
We could do that.
Noon till, I mean, what time is good? 11 to 2? What? He sounds like he will go anywhere that you ask him to so he can see his child.
We can do 11 to 2 or 11 to 3. I'm not sure what their hours are. We can work that, yes.
All right. And that'll be every other Saturday?
Yes.
And then every Wednesday night from what to what? Pick a spot.
I get to work at 5:30, so probably about 6, maybe an hour or two. We could do that.
6 to 7:30?
We could do that.
And we're at the library again, or do you want to do McDonald's or something?
We could do on the weekends at the library and then McDonald's on Wednesdays.
All right. And which McDonald's?
The one closer to him, because I know I don't mind driving over there.
All right. But do you know where it is? Because so I can put it in there or something. Do you know where she's talking about?
Yes. No, I really don't know what she's talking about, Your Honor. Like, I mean, I know the library, but I'm not sure what McDonald's she's talking about.
There is a play place on Lake Michigan near my house, but that's the only one that I know of on Lake Michigan. Sorry, that's the one I do know.
Or, I mean, it doesn't have to be McDonald's. I'm not trying to, it can be Burger King. It can be it can be any place you think is all right. It doesn't even have to be a place. You could meet at the mall or something at the food court or whatever.
Yeah, we can do that. Can we leave that open for as long as there's no fighting or arguing?
All right, 6 to 7:30 every Wednesday at an agreed upon location, but tell him this Wednesday where you're going to meet.
Yes, sir. I can do that. This Wednesday, where would you like to meet? I want to be.
No,
I want to work with you.
Like it's like you're in control. You know what I mean? Like
don't make this worse than it is. Just tell me where you want to meet on Wednesday at 6 o'clock.
I mean, she's the one with the vehicle. You know what I mean? And it doesn't matter. I would meet my daughter wherever you want to meet. You know I don't have a problem with that. I never have.
I know you do, and she's being really nice and saying pick a spot, and she'll be there. You want her to pick a spot?
Yes, that is fine.
Ma'am, fire away.
Okay, we'll meet at McDonald's on Lake Michigan this Wednesday.
Find where it is.
Yes, it is.
McDonald's this Wednesday. Can he see her tomorrow, 11 to 2 at the library?
Yes, we can meet tomorrow.
Here, all right, sir?
Yes, sir.
Starting tomorrow and every other Saturday, 11 till 2 at the Wyoming Library. Also, every Wednesday night, 6 to 7:30 at the McDonald's on Lake Michigan Drive. But you guys can change this, okay? But make sure you both agree on it. All right?
We can do that, yes.
But this Wednesday, McDonald's at Lake Michigan Drive. I'm not going to be there to make sure that you meet at McDonald's if you guys agree, but you should at a minimum, if you're going to do something else somewhere, at least make sure that you have some kind of written agreement that it is. It can be through text or whatever, that, you know, you both say, okay, I'll meet you at 6 o'clock at the food court at Rivertown, you know, whatever, right? Because I don't want to come back and have this.
Yes, sir.
I'm gonna refer the friend of the court for child support. And we will leave modification of the parenting time to some other time. If you want to modify it later after you're doing some of this kind of stuff and you want more time or something, you can file a motion, okay?
Yes, sir.
All right, sir, any questions?
No, I'm good.
Tomorrow, 11 o'clock, Wyoming Library. Okay?
Thank you.
Thank you, everyone. Take care.
Thank you.
8 PM, Collins v. Collins. We have the plaintiff, Miss Collins, present. Mr. Collins is not. How'd you get him notice of this hearing, ma'am? Hello, you're on.
Hi, sorry about that. I actually did not get an email notice or anything, and I was told I would. So I actually went down to the courthouse and they gave me the Zoom meeting information. So
How did you get the information of this hearing to Mr. Collins?
I mailed him, and he actually texted me and told me that he got it. So
When was that?
he texted me, I think Monday.
Okay, when did you mail it to him?
I mailed it the same day that I filed it.
So on the 9th, all right.
Yeah, because he thought that the hearing was on Wednesday, and I told him no, it's on Friday at 8:30, and I told him it's a Zoom meeting.
And you, all right, we have not seen him log in at any time, so this is the plaintiff's request for child support. Back in 2023, they agreed to a deviation so that they only paid ordinary medical, and it was because a lot of overnights and things. There's a change of circumstance, at least for the friend of the court to review this, as she says the child no longer spends no nights with the father. Is that correct?
That is correct.
So he doesn't see the child very much anymore. Is that correct?
No, there's been a lot of changes in his home environment, so my son has not been out that way. His father stays in Southfield, which is near Detroit, so he's pretty far from us anyway.
All right, well, this child support order is it's about a year old, but there was a deviation that the parties agreed to. It appears that he doesn't have 70 overnights like the last order found him to have. So I'm going to refer this back to the friend of the court so that they can come up with an appropriate amount for child support. All right, and I don't think a deviation is going to be appropriate this time. You'll be able to give him all the financial information. He will give him the number of overnights, which appears to be 0, and they will calculate an appropriate amount. It will start at the time of the filing of this motion, retroactive to the date the filing of the motion, and we'll get to the bottom of it. Make sure that you cooperate with the friend of the court when they ask you for your financial information and stuff, okay?
Yes. Yep.
Now, I'm not going to read your address because we're on YouTube, but it's 1120.
Yes, that's correct.
All right. Make sure the friend of the court knows that also.
Okay.
Yeah, I don't know if you moved at all or if they have your correct address or whatever, but make sure they have it because they're going to send it to the last address that they have. And I want, I don't want them to come back and say, gee, we didn't get any cooperation from her. And you say, I didn't get anything. Okay. You'll get something as long as they have it. Okay.
Okay.
All right. Good luck. Take care.
Thank you.
Thank you.
Yep.
DP Ortiz versus Cole. This is an adjourned hearing from back in, looks like July. Looked like we adjourned it for about 4 weeks. This is the mother's parenting time motion. It's clear that we're dealing with a child, an older child. I don't know. How old is she?
She's 13.
13. Has been living in his custody with her father. Mother made certain allegations about the father. The plaintiff did log on here early on, but logged off shortly thereafter and has not been back at all.
Yeah, he texted me saying that he wasn't going to sit around and wait all day.
Oh, that's good. Part of it, he wouldn't have waited as long because we wait to try and get 2 people together and bring them in. Okay, but he obviously didn't want to do that. I basically adjourned this, then the court order said granted extended parenting time through today's date to allow the defendant to provide the court with CPS documentation and stuff. Mother has said that CPS was working down, I think, in Florida and all that kind of stuff. Ma'am, where are we at with this? I don't have anything more than I had then.
Yeah, I tried getting the documentation and I spoke to Miss Stephanie, who's the caseworker involved with the CPS case. And she advised me that whenever she originally went out and saw my daughter, that she had concerns. And when she went out again and questioned her, that she said she felt safe. So she didn't feel as if it was going to be relevant in the situation and it wasn't really going to be helpful in trying to get her.
Okay, so, I mean, the child moved down there to North Carolina with you. I mean, what am I supposed to, I guess without anything, I don't change any orders.
What I mean, I do think it is still in the best interest to at least I've never wanted to keep her from her dad. That was never any intention of mine. I do have concerns because he is a violent person, but I can't put what's happened between him and I into this situation. I'm just going based off of what she's told me as a concerned mother. But I do feel that it is in her best interest to do at least joint parenting time because of the fact that he has not in the past cooperated, or he's made it difficult for me to have her and to see her, and didn't cooperate with the shared parenting time court order that we already had in place. Now we've discussed things and he's willing to let me have her for the summers and for the holidays and stuff like that. But in the past, he's never really cooperated and made anything easy for me.
Yeah, so, well, I mean, the order of her being with you ends today, okay? And we go back to the prior order. You say you want some specific parenting time. You guys don't live close enough that you can't do every other weekend and stuff like that. You live in North Carolina, you live in Florida. Okay.
Yes. Yeah. The current parenting time was where I was supposed to have her for every other weekend. And whenever I was living in Florida, he refused to let me have her. And I had to move because I have 2 toddlers now and I had to move to be closer to family. My mother-in-law's only 6. So that's why we're here in North Carolina. But regardless, I do feel as if, summers, holidays, stuff like that would be beneficial for her. This way she has more parenting time with both of us. She's not just with him, and she has the ability to spend the time with me without us needing to jump through the hoops and everything that he kind of always requires. It also give her equal influence with both of us versus just one of us. I'm so sorry.
Well, I mean, obviously the old parenting time order doesn't really do much. Oops, did you leave?
No, I'm here. Sorry. I apologize. I was trying to put my toddler over there for a second so that way he's quiet.
All right.
I'm so sorry. I have 2 toddlers.
Well, like I say, trying to find the old shall have parenting time every other weekend was from in 2021. Talked about transportation, things like that. I don't know that we have any other parenting time order in place, and that would be motion to set aside parenting time order. Previous order parenting time be vacated. Beginning Saturday, the defendant shall have parenting time for 4 consecutive weeks from 3 o'clock. Whatever, that's in Florida. That was in June of 2021. I don't think we have any other orders which are clearly outdated because nobody lives in, well, he lives in Florida, but you don't live in Florida. And nobody lives in Michigan. So I guess the best thing I could do is set some kind of parenting time. You say he wants what? He wants you to have, when she's out of school, what, you get 8 weeks in the summer or something?
Right. So I would have her during the summer, during holiday breaks, spring breaks, basically any holiday break, unless she chooses to stay there for that holiday. But we've already discussed it, and it would be the summer and then every other holiday or spring break that she might have for schooling.
Well, then why don't you look? I can't really just order that because he's not here. Okay.
Right.
Why don't you guys just sit down, write something down about what you agree to, and put it in the form of a court order, and I'll sign it.
Okay. How would I get that to you?
Mail it to my clerk.
Okay. So I guess I can contact her and arrange to get the address and everything set up.
Yeah. Yeah.
Ideally, though, it would, what I really would like to do is, because she doesn't live in Michigan, I never lived there, but he hasn't lived there since 2018. What I really would like to do is try and have the case domesticated. I mean, ideally, she currently resides in Florida, so it would be Florida, or if we would have to do it
I'd
here.
ideally like to get it domesticated in Florida or something too, because I'm dealing with people who live in Florida and North Carolina and have no connection with the state of Michigan, but it's here until it gets transferred.
Right.
Okay?
Yeah. How would I go about doing that? Is that something that you would be able to assist with, or?
Not really. You should, I mean, it'd probably be domesticated in Florida. You really need to talk to an attorney about that stuff.
Okay.
I can't really give you advice on that.
Right.
See if you can get it domesticated, Florida or North Carolina. I don't care what. I mean, I do feel like it's odd that I'm dealing with this when nobody lives here or is going to live here, and it's not like you even live in Ohio, which is close. You know,
Right.
you're the closest one in North Carolina.
I do agree. I've tried contacting the legal assistance center in Florida, and then I've tried here, and they've each told me they cannot help me, and I can't do anything to modify anything or to file for custody in my state because there's already an open case in Michigan. So I've done my due diligence, but I just don't know. I don't know what to do other than to
I can't make them accept my case. Okay.
Yeah.
You just have to talk to somebody and try and get that fixed. In the meantime, just do a stipulated order there. I mean, you can probably get something that says probably off the online stuff here, even with the, what do we call it? Legal Assistance Center.
Yeah.
Legal Assistance Center here in Michigan in this courtroom. They probably have something online that says stipulation and order on it, and you would fill it out, and the two of you would sign it and say, she'll get summer parenting time and this and that, send it in to my clerk, and I can't imagine that I would not sign it, okay? Because if you guys agree on it, I don't want to get in the middle of it.
Yeah.
All right?
Yeah. And the reason I wanted to continue with this and talk to you at least was because he, in the past, has always used, I have legal custody of her. There's nothing that you can do. And because he's very narcissistic, he jumps back and forth, and it's either his way or no way. So it's hard to not have anything in writing.
Yeah, but I can't give it to you saying he agrees to it when he's not here. If he agreed to it on the record, we'd draft the order probably.
Okay.
Clerk would, and she'd be, even though you guys should do it, but if he was here and agreed to it on the record, we could find an agreement and make that an order. But without that, go online to the Kent County Legal Assistance Center, see if you can't find something called a stipulation and order, fill it out, the two of you sign it, send it back to my clerk, and we'll sign it.
Yeah.
All right?
Yeah. And there's no way I can text him and tell him if he can join now, or is it too late for him to do that?
We've got a couple more cases. I'm not gonna keep going. If he wants to get in here and my clerk finds that both of you are online, maybe we can do that.
Okay.
Okay, I'm not saying if he gets online, he's gotta wait a couple minutes because there are other cases, okay?
Right.
But, we can probably reach an agreement if he wants to.
Okay. I texted him, so I'll see what he says.
All right. We'll see if you join back. We'll try and do something. Good luck, ma'am. Thank you.
Okay. Thank you so much.
Hello?
Hello, Ms. Garcia.
Yes.
All right, we are here in case of Garcia Cruces versus Colorado Gonzalez. We have the plaintiff mother on Zoom. The defendant has logged on, but logged back off and hasn't been back on. I don't know why. This is a motion filed by the plaintiff mother to find that the child was born out of wedlock. Ma'am, I can't do anything unless I have a DNA test showing that he's not the father. So we'll issue an order requiring the parties to provide a DNA test when it comes back, assuming that he's not the father. You can take further steps then to get him off being father, okay? Okay. So we'll issue an order to you and to him to do a DNA test, and we'll see you back in the near future, okay?
Okay, so where I take her to do the DNA test?
It'll be, we'll send out an order to you and you'll figure all that stuff out, okay?
Sounds good.
All right, thank you very much.
Thank you.
It costs, and because you're here and trying to do it, you're gonna have to pay the fee for the
Okay.
DNA test, okay? I think it's $300, okay?
Okay, yeah, that's fine.
All right, thank you very much. Take care.
Too. Bye-bye.
It's a matter of Wynn versus Helong.
Yes.
This is the plaintiff is present. Was the defendant ever? Did you get him notice of this motion, ma'am?
Yes.
How?
If you want, like he in Vietnam now,
How
and
did you get notice?
over there he's nighttime. I tell him like when I get your message, I'm gonna call him, so let him know he get
You're
in
gonna
the.
call him so he can get online?
Yes.
Please do it right now.
Hang on
Well,
one second.
let me. All right. This would be Mr. Helong is what you're calling?
Yes. And then he's not really good at those stuff. Usually I do it for him, but I'll get a call for him right now. Okay.
Call him right now.
Yes. Are you mind if we talk with him on the phone? Like I call him right now and you talk with him.
Well, ma'am, you have a DNA test here that
Yes.
shows that he is not the father, correct?
Yes.
Do you know if he objects to that? I mean, has he ever had any contact with the child?
Yes, he did. We separate long time. He know the child, the father of the child too, because we're not good at the paper. So it takes forever for us to complete the case, but we all know.
Isn't the child only 4 months old?
Yes.
And so does he want to be the father of this child?
No, because like we want to put like his real father on the birth certificate, so we go for divorce paper, so I can like make the paper for the child.
Well, is he going to be on this call in right now? He needs to log in on Zoom if he's going to be here.
Okay, 1 second. I'll go get I borrow another phone to call him.
Well, why don't we put you in the waiting room? You call him and get him on Zoom, and we'll take one other case, and then we'll get back to you.
Okay, yeah. Thank you.
Thank you. Is this the last one? Oh, this is, we have Ms. Valdez Diaz present, Mr. Hernandez. The defendant is not present. He has not been on Zoom at any time. Did you send him notice of this?
Yes.
When? You're frozen.
On the yes, on the 13th.
The 13th? You mailed it to
The
him?
day when I yes.
All
Yes.
right. Do you know if he got it? Has he had any contact with you?
No, he no contact with me.
All right. He's not logged in. He apparently has notice of this. This is simply a request by the mother to find that the defendant is not the father of Scarlett. It appears that the defendant did not participate in a DNA test, but the father, the alleged father, did participate in it. It shows that Mr. Garcia is 99.99992% the father of Scarlett.
Yes.
Correct?
Yes.
All right. And so she is asking that this matter be found that the child is born out of wedlock. I think having reviewed this, I mean, has Mr. Hernandez had anything to do with Scarlett? Does he treat her, does he take her for parenting time or anything?
He live with me.
He lives with you?
Mm-hmm.
And he wants to, not be declared father or what?
No, so we separate with Mr. Hernandez. So
That's what I asked you. Does Mr. Hernandez have anything to do with Scarlett?
he is not the father of Scarlett.
All right.
That's why he's not in this court, because he say in the last court we don't have nothing to do, only the divorce, because we don't have kids.
All right. The court will find that Skylar was born out of wedlock and that the defendant is not the father. There are no other children in this divorce. Is that correct?
It's not any.
So we will change this to a DO divorce and you can proceed towards completing it whenever you can get around to it. I'm not doing anything with that, but father, we will find that Mr. Hernandez is not the father. All right?
All right.
Thank you. You'll still have to work on completing your divorce. Okay?
So we have a next court on the 10th with you.
On
So
the
this is
10th?
for the complete the divorce?
Do you know what we have on the 10th? No, I don't think I wouldn't be to complete the divorce. It might be a scheduling conference or something.
Okay. So you processing the
Or,
divorce?
or no,
with
wait a
this?
minute. I think you might have something with, maybe to enter a default judgment, and it's probably with referee commits. Cause that's where we got the file from.
Okay.
All right. So you
All
can
right.
proceed on however you're going to, but today I'm gonna make the order that Mr. Hernandez is not the father of Scarlett.
All
Okay?
right.
All right. Thank you very much. Good luck.
Thank you so much.
We're
Bye-bye.
adjourned. Are they back in? Are both? All right, Ms. Nguyen, and we have Mr. Halong. How long are you there and can you hear me?
I do.
Okay, it's apparent that, the child that was born who's 4 months old, Keenan, there is an order that shows that the father, the alleged parent, the alleged legal father, is not the biological father of this child. Do you agree with that, sir? Mr. Long, did you see a
Yes.
copy? Yes?
It's not mine.
Okay. You are married at this point, aren't you?
And that time, yes.
Yes. All right. Well, the court will enter an order that says that Keenan is not your child, and as a result, ma'am, you can proceed. The two of you can proceed to get this divorce over with, and however you do. But I will make the order that he is not the legal father, that the child was born out of wedlock. Okay,
Yes.
ma'am, you understand that? All right, you can proceed to bring this divorce to a conclusion however you want to at this point. All right, good luck.
Thank you.
You both very much. We're adjourned.
Thank you, sir. Thank you for your time. Thank you.
Thank you.
Yep.
I thought you said this was the last one. Yes, you did. You said we had 3 others and they were all there. Oh. Well, it was the last one. Is he logged in?
He said that he was joining. It was showing that he's joining.
Can you get, okay. Mr. Ortiz, can you hear me? And if so, you're on mute, so I can't hear you or see you. There you are.
Okay.
Oh,
Can you hear me?
yes, I can.
Okay, there we go.
All right. We're here in Ortiz versus Cole, back on the record. It's my understanding, we've gone through some stuff before in July, and now we're here in August, and it's according to Miss Cole, and it's kind of odd because you live in Florida, don't you?
Yes, sir.
She lives in North Carolina, and I'm dealing with this in Michigan, all right? I'd like to be in either of those states come winter, but not right now. It's pretty nice up here, but we'll see what happens. Have you guys reached some kind of an agreement for parenting time? Miss Cole seems to think that, you know, she'll get a lot of the summer and maybe some of the breaks. You're gonna have the school year and that kind of stuff. If you have, we can do a stipulated order by both of you agreeing on it. If not, I have to have some kind of parenting time hearing and this kind of stuff. Tell me, Mr. Ortiz, have you made any kind of an agreement on things?
Yes, me and Ms. Cole actually spoke. I also spoke to Ileana. Ileana does want to go out there on holidays and like the days that she got out of school and things like that. Like she gets free time out of school. So I told her that was no problem. However, she did say that she wanted like one Christmas with her, one Christmas with me, one Christmas. She wanted to alternate within certain holidays. She said those she wanted to alternate, and that Halloween she wanted to stay with me.
Yeah, I wouldn't send her up on Halloween because I'm not from Florida to North Carolina for one night. Okay.
Yeah.
Yeah.
So things like that. So the major holidays, like she wants to alternate. So I said that's fine. You know, everything I've discussed with Ms. Cole, I've also discussed it with Ileana before anything. And within the three, this is what we agreed on. So since Ileana majority of the time is with me because she goes to school here in Florida, you know. So yeah, I have no problem with that.
Well, we either got to enter something as an order that the court can enforce or we don't, and that's not great, okay? But, I mean, are you saying she'd spend time with mom in the summer? How many weeks in the summer?
First time in a long time that she's ever went with, actually ever. She went with Miss Cole for about the last 2 months. She went with Miss Cole for the summer.
So do you agree that she can have 8 weeks of parenting time in the summer with mom?
Yeah, pretty much whatever mom and Ileana decides what they want to do. Pretty much, I'm okay with it, you know, because Ileana's at the age where she could defend herself. You know, she's
Well, I understand.
So I'm okay with it. You know, I'm fine. You know, I've also discussed with Miss Cole, like I said, you know, we came out to these agreements as well.
All right. All I'm trying to do is get it into a court order so it's enforceable. Okay.
Yeah, that's fine.
And then if you guys want to modify it, I don't care. Okay. Because I'm not going to be there to watch every minute that you have. But
Correct.
but it's a baseline that, like, if you say no, you can't have 8 weeks in the summer, she does get it. Okay.
Right.
Now, if the two of you agreed to do something different, that's fine. But
I just asked from her that she doesn't send her totally the last week because I have to prepare her for the whole
I agree with that.
everything.
Absolutely.
I need to give me a couple weeks before she does that so I can get her to the doctors and get her physicals done because that takes a lot of time.
No, child must be returned a minimum of a week before school starts. Okay. Is that enough? Or maybe, why don't we do a minimum of 2 weeks?
2 weeks. Yeah. Give me at least 2 weeks. Yeah. That would be cool.
8 weeks in the summer, returned 2 weeks prior to school starting. You guys gonna split Christmas break and every other year child spends Christmas, you know, you alternate Christmas?
Yeah, I'm okay with that.
I assume Florida schools have something like up here, like 2 weeks off or something?
Something like that, about 2.5 weeks, depending where they land on.
All right, so
it really depends on how the school feels because sometimes they don't want to open, they just won't open.
Split Christmas break.
Can we kind of leave that in a way to where it's up to her? I mean, yeah, like everybody.
You guys can do whatever you want.
Okay.
Okay. But I'm gonna put it in an order so that in case you come back, Ms. Cole, and say, hey, I didn't get any time, you know, that you have something that's enforceable. Or if he comes back and says, wait a minute, she kept the whole time, you know, it would be contempt. All right. But there is nobody who's going to interfere with the two of you agreeing on stuff. But if I don't put it in, and I don't care, I don't have to do any order at all. But you realize, Ms. Cole, that at that point, you don't have any enforceable anything.
Right. And I appreciate you doing that.
All right. That's all. I'm just saying split Christmas break with alternate Christmas with each parent. All right. So you'll alternate and you can figure out how to split it equally. Okay. Equally split Christmas break, but whatever it is, who gets Christmas this year?
It really doesn't matter. I mean, I haven't really spoken to that. She's like, oh, I don't know yet. So she really hasn't told me if she wants to go with Miss Cole or something.
All right.
I want to leave that open for us.
I'll just make sure that you alternate. So whoever gets this first Christmas isn't going to get it next Christmas. Okay?
Correct.
Okay.
So, and you will split Christmas break equally. Yeah, but again, I'm not gonna be there to check on this, okay?
Yeah.
But you guys, the only thing this is there for is if you can't agree, all right? This is what the court order is. Every other what? Thanksgiving with the parties?
That's fine.
Thanksgiving break to be alternated.
Sorry,
Right.
give me one.
So that, and then I'm gonna leave it up to you. It's at least, you know, the whole Christmas, the whole Thanksgiving break will be alternated. And you'll alternate spring break from school.
Okay.
All right. And so whoever gets the next spring break, the other one gets the following one. There's no argument. As far as, that's all I'm gonna put in there. And what I'm gonna say is any other time agreed upon between the parties. You, I hope, will just plain work this out, but this is a bare minimum that can be enforced by the court. Okay?
Okay.
It sounds like for the first time, I mean, this case has been around for a while. It sounds like for the first time, maybe you guys are starting to reach some kind of a neutral ground because your daughter's getting older and both of you want to be involved in her life and hopefully are. All right? Thank you for getting back on, Mr. Ortiz. Makes it much easier. We'll issue that order. When you look at it, if somebody has a real problem with it, contact me back. But it's simply gonna say she gets 8 weeks in the summer. However, the child must be returned 2 weeks prior to the commencement of school. All right, so figure that out. I mean, if it turned out that there were only 9 weeks, she still has to be back. You'd lose one of your 8 weeks, okay? She has to be with him 2 weeks before school starts.
Okay, which is understandable.
Yeah, equally split the Christmas break with the Christmas holiday alternating between the parties. Thanksgiving is the same thing. You will alternate Thanksgiving break and you'll alternate spring break. Good luck, everybody. Do both of you agree to this, what I'm saying here? Mr. Ortiz?
Yes, I agree.
All right, Ms. Cole.
Is
Thank you
this something-
very much.
I apologize really quick. I have a question. Do you mail this order to us?
Yes.
Okay. I don't know if you have really either of our updated